Let me put myself up on the screen. Hello, everybody. What is going on? I'm gonna fix my mic to get closer to me here. All right, we are about to start. Oh, thanks. I'm glad everybody's enjoying it. So this morning we got some motions that they gotta start today. So, hey, everybody. Hey, of course, John O'Brien, the lawyer. John. I think John's a lawyer because he knows it all. Hey, what's going on? How you doing? Thanks for stopping by. Thanks for watching this. I'm hoping this is helpful for everybody. Can't wait.
Have several issues to take care of this morning. First and foremost is the defense motion for judgment of acquittal. Mr. Nelson.
There we go. That's what we were saying yesterday. The defense. This was yesterday. Remember what you said?
Your Honor,
they should put a motion in for judgment of acquittal.
Yesterday,
here we go.
In terms of the timeliness of this motion, at this point, the defense moves pursuant to Minnesota Rule of Criminal Procedure 26.03, subdivision 18, paren 1, for a judgment of acquittal in this particular case.
The defense is saying that the prosecution has not proved their case. So he's saying the case should be dismissed now.
At this point,
so this is what he's doing now. They're asking for this case to be dismissed.
Sufficient evidence, even in the light most favorable to the state, to establish.
Thank you for the time for the super chat.
Principal issues or.
Oh, they're having problems.
The use of force and whether the use of force was reasonable, as well as the cause of death of Mr. Floyd. Starting first and foremost with the use of force, what the state has essentially done is provided 6 different opinions from various police officers or use of force experts, all of which seem to contradict themselves or each other. For example, Sergeant Pluger testified, and Sergeant Pluger and Jody Steiger, I would say, are the only two who have had a consistent opinion that the use of force became unreasonable at a point that Mr. Floyd ceased struggling. Mr. Zimmerman or Lieutenant Zimmerman had the opinion that even at the point of, that the force became unreasonable, use of force became unreasonable when Mr. Floyd was a real.
Just so everybody understands, this is probably going to be denied, right? Like 99.9% of the time these are denied. So. But you do this, right? Just for the hell of it.
They even disagreed with each other. So you have a myriad of inconsistent, complicated use of force opinions that really demonstrate the difficulty of establishing beyond a reasonable doubt that the use of force was objectively unreasonable, which is the standard under Graham
v. Connor.
Well, they all ultimately said it was objectively unreasonable at some point. The question is when did it become?
Thanks for joining, Haley.
Again, 6 or 7 different opinions on that. In addition, Your Honor, in terms of the medical evidence, the court is aware the cause of death has to be proven beyond a reasonable doubt.
Yes, it does.
You have the testimony of Drs. Tobin, Dr. Rich, and Dr. Smock, who ultimately testified.
No, the jury is not present.
Lindsay Thomas. Those 4 doctors ultimately concluded that it was an asphyxial death. However, the state likewise presented Dr. Baker's testimony, which in large part, while he declared it a homicide for medical purposes, which is not a statement of criminal.
Oh, good luck.
The criminal standard, Dr. Baker suggested something much different. Which
I don't think so.
That Mr. Floyd.
That's horrible if Chauvin testifies.
The stress of the circumstances. So, Your Honor, the state.
Thanks for coming to member. Thank you.
Doubt in the context of providing multiple opinions from multiple experts, all of which seem to contradict each other, and for that reason, we would ask the state to.
This is their feed that's choppy.
Right. For the state.
So essentially, Nelson is saying the state has not proved its case, even if he doesn't put on a defense. The state hasn't proved anything.
Thank you, Your Honor. The state
and it should be dismissed.
The defendant's motion for a judgment of acquittal. The evidence taken in the light most favorable to the state, as we've presented it, establishes all of the elements of all of the crimes charged and negates the defense of reasonable use of force. The issue is not whether there are inconsistencies, minor inconsistencies in
cool.
what
Let me-
witnesses say. The issue is whether, taken as a whole, the state has
Make
proved
this
its
audio
case
a
in
little-
terms of the
All right, here we
force
go.
analysis or reasonable
Hopefully
force.
that audio
There's
level
no question that
is
the
better. Let me
witnesses
turn
who have
my audio down.
testified have
I
all
can't turn
opined
the.
that the defendant's
Can you guys
force
hear me?
was
Am I
objectively
good? Am I better? Is it a better audio level with the trial?
unreasonable. He
I'm
was
bringing
not
mine down a
trained to
bit.
do the circumstances.
Let me
and
know if
simply
that's better, guys.
continued on too long.
And it's their feed
As
that's
to the
choppy.
medical
Let me see what
causation
mine's doing.
issue, Your Honor, the state has introduced evidence that, if believed by a reasonable jury, clearly established that the
All right.
defendant's
Yes. Yes.
conduct
Good. Thanks.
was a causal factor in bringing
Perfect.
about
All right.
Mr.
Thank you,
Floyd's
guys.
death through the pulmonologist, through Dr. Baker, through the other witnesses who testified. And so, taken as a whole, the state believes that it's established and will establish beyond a reasonable doubt that the defendant is guilty of all charges. Thank you.
What this does gives you a preview of the defense's closing.
I'm
what
going to
they're gonna be
deny
saying
the
in closing.
defense motion for judgment of acquittal. I would note the standard, unlike a jury, which has to decide whether the case has been proven beyond a reasonable.
Oh, come on. Why is your feed so choppy? This isn't even. Let me see if I can find another feed. But the judge essentially denied it. Now, if the judge would have given a judgment of acquittal, Chauvin wouldn't have been able to be charged again. That's it, right? He's done. That's it. It's over. So the judge has denied it.
Doubt, and in doing so must presume the defendant innocent. Most favorable to the state, they could give their greatest weight to those witnesses who establish that the use of force was unreasonable and that the cause of death was positional asphyxia or lack of oxygen, however the state wishes to characterize it, but most importantly that it was caused by the defendant. That is viewing the evidence in the light most favorable to the state. It is clear that that has been established. And so based on that standard, the motion for judgment of acquittal is denied. All right. I think we told.
Let me try to find another feed because this one is just.
Counsel for Mr. Hall to be issues other than.
All right. I am going to change. I'm going to change the feed because that feed just was not was acting up. Let's watch some PBS NewsHour. Even though PBS has got some issues going on now, especially with their Hunter Biden stuff. But sorry guys, I had to change the feed because that feed was just horrible. Here we go. Let's watch some PBS NewsHour. That should be better. Play this.
That standard, the motion for judgment of acquittal is denied. All right. Did anyone want to address any issues other than that? All
right, here we go.
All right. Could we, is Mr. Hall present?
But Mr. Hall, for those of you who don't know, Mr. Hall was the alleged drug dealer that refused to testify because if he testified he gave George Floyd drugs and George Floyd subsequently died, he could be charged with felony murder. So he's like, I'm not saying nothing, right? I'm not testifying that I was in a car with drugs and I can be charged with third-degree felony murder like the cop. It ain't happening. So now they're trying to. So that's what Mr. Nelson. He wants this guy. He wants a drug dealer. I want the drug dealer to testify. The drug dealer saying hell to the nah. It ain't happening. And the drug dealer's lawyer saying, hell nah, it ain't happening. Yeah, but nobody's saying nothing in the trial. So when it comes up, we'll get back to it.
All right. Well, let's just reconvene at 9 o'clock then, at the scheduled time.
They are reconvening for 9 o'clock. So let me look for a couple of feeds because there's different feeds with different. They got 5 minutes. There are different feeds with different audio. So let me look. I'm gonna look for another one with better audio because the last one was too choppy. This one's too low. Yeah. So what we're going to be hearing from next is the drug dealer, right? Again, I got to make sure I said the alleged drug dealer. So just so everybody understands what's going on this morning. This morning we have motions, right? This is outside the purview of the jury. So the jury is not in here. And the court's coming on and saying, so first Nelson comes up and he says, well, listen, the state hasn't proven their case, right? And since the state hasn't proven their case, Chauvin has a presumption of innocence. give him an acquittal. Now, if the judge would have granted that motion, then Chauvin could not have been recharged, right? Double jeopardy attaches, it's over. The judge said, no, the state has proven their case enough where a reasonable jury can find him guilty of all the charges. Great. So now the defense has to continue to put on its case to knock down. The good thing we got from this morning, though, that everybody, if you can go back and watch what the defense attorney said, you got a good idea of how he's going to close, what he's going to say to close. And that's probably why he didn't want to say that yesterday, because he has, he's given a preview. These people are conflicted. The use of force experts are conflicted. Some of the doctors are conflicted. So now the prosecution understands that and says, well, I'm going, now we can go into this, right? We can go into this, breaking this down, right? We now know what he's going to say. So it's a nice little tactical, it gives the prosecution a nice little tactical advantage of this. So we will see. Hey, what's going on? Allegedly, but factually true drug dealer. Well, you know what? I just want to be more accurate. He's, if he is, if he's not, he gave a lot of misinformation. Like that guy, don't forget, it's not like he should just go and testify. He could legitimately, right? Legitimately. He could be facing a felony murder charge for selling drugs to George Floyd, and George Floyd died. That's something that's worrisome. I wouldn't have my client testify. Like, would any of you? Let me see if is anybody in the chat who was this alleged drug dealer? Would anybody here? Ricky Ricardo, that's what he said his name was yesterday. Ricky Ricardo. Would anybody here, right? Would anybody here testify if they were Mr. Hall, the alleged drug dealer? Would you go and testify that you were in that car with drugs and that Floyd, you might have given Floyd some of those drugs and he died? Don't forget, you got 2 warrants, all this other stuff too. No, I would not. It's insane. It's insane for him to testify. The girlfriend, yeah, she didn't do anything. Him, no. So that's what he's saying. I am not telling you nothing. I don't care who it helps. I don't care who it hurts. I am not getting on the stand. And that's just real talk. That's why we have, God bless America and our Fifth Amendment privileges not to say crap when the government comes calling. Reasonable doubt. Now, listen, somebody asked me to explain reasonable doubt. Let's just say this. Reasonable doubt is doubt that in one of your more important moments, let's say you get diagnosed with a horrible disease and you go to 20 doctors and all 20 doctors say you got this disease and you take pill X and it should help you out, right? Reasonable doubt would not allow a person to say, well, I'm just going to ignore all 20 doctors and I'm not going to take the pill, right? Because there's no reasonable doubt. A person of normal intelligence and who's ordinarily prudent, right? Who's a prudent person would trust the expert testimony, right? Would trust the fact that all these doctors are saying the same thing. So it's unreasonable, right, for someone who's just, who's being reasonable to say, no, I'm not going to trust all these experts. So that's what reasonable about it is. You're supposed to say, if this is an important moment in your life, would it be reasonable for you not to accept what you're hearing, or would it not be reasonable? And that's essentially how you're testing reasonable doubt. If you got some horrible news, if you got something important in your life, and you had to take someone else's opinion or someone else's word for it, how would that work out? Let me get another. Let me find another feed real quick, because this feed was horrible. Let me try to start Tribune again. Here it is. The drug dealer's on. We are on. The drug dealer's on. Sorry, guys. Let me place this. Oops.
Whatever happens with this case, the state can still come back and charge Mr.
I'm gonna roll it back a little bit.
Floyd.
Looked.
Not his fifth.
Cousins, if you could come up to the podium.
All right, so this is the alleged drug dealers. Alleged drug dealers. Hopefully you guys can all hear this. This is the alleged drug dealers.
Good morning,
attorney.
Your Honor. Adrian Cousins and Jeff Isaacman appearing on behalf of Mr. Hall, who again is present, and whether or not his Fifth Amendment privilege would be implicated in those questions. I've had a chance to review those questions, Judge. I've reviewed them with Mr. Hall, And to summarize, Mr. Hall cannot answer any of the questions that defense put forward. And I'm happy to expand on the reasons why
Shocking.
he can't.
The drug
answer
dealer
any of
can't
those
answer
questions.
any of those questions.
Let's
Shocking,
just
right?
focus on how Mr. Floyd looked in the SUV, because that was the very limited group of questions that I thought might not incriminate him.
Absolutely, Judge. And if you look at the list that defense proposed, I think that really starts getting into that topic at question with Mr. Floyd. Again, this was a car that was searched twice and drugs were recovered twice. If Mr. Hall puts himself in that car, he exposes himself to constructive possession charges of the drugs that were found in that car. And it's important to note, Judge, that Mr. Hall exposes himself to that charge whether or not Mr. Chauvin is convicted or acquitted. Whatever happens with this case, the state can still come back and charge Mr. Hall with constructive possession of drugs in that car. So he can't put himself in that car. Furthermore, the questions that come after that. Did you notice a change in Mr. Floyd's behavior while sitting in the car? How would you describe his behavior? Did you tell BCA agents that Mr. Floyd was drowsy or asleep? Mr. Hall cannot answer any of those questions without potentially incriminating himself. But there's a potential third-degree murder liability here under that overdose statute, which again is very broad. If Mr. Hall puts himself in that car, he's now establishing a timeline of events. So let's say Mr. Hall takes the stand. He very limitedly testifies to, this is what Mr. Floyd was doing. This is how Mr. Floyd looked. These were his behaviors. This is the change in his behaviors. Let's say Mr. Chauvin is then acquitted. He is now given the state on a silver platter testimony to use against him in a third-degree murder charge if they decide to bring it.
All right. Thank you. Mr. Hall, I'm going to have you step up to the podium because I'm going to ask you a few questions, basically whether you are going to invoke your Fifth Amendment privilege. So if you could swap places with your attorney.
Hell yeah, I'm going to invoke it. No, I'm not answering crap. Third-degree murder? No. Do you think the residual exception value?
That?
Hold on.
Yes.
All right. And you understand that applies even when you are not one of the parties to the case, but when you're a witness in a trial. Do you understand that?
Yes.
You understand that your attorney, and I'm sure they have given you advice about whether to invoke your Fifth Amendment right against compelled self-incrimination.
John
but
O'Brien.
Ultimately, it's your choice.
No,
You
because
understand that?
you can't let them plead
Right,
the fifth in
and
front of a
let's
jury.
speak up just a little bit, and I'll turn up the podium.
They'll misuse it. They'll misuse it to believe he's guilty
There
of
we go.
something. So you can't do that.
You understand this is your choice, so you could disregard the advice of your attorneys if you wanted to.
Yes, sir.
Knowing all that,
Hell no.
You've had a chance to look at the questions that were proposed by both sides.
I have.
Would you be willing to answer those if I were to put you on the stand and swear you in as a witness?
No, I am not.
Okay, and why would you not answer those?
I'm fearful of criminal charges going forward. I have open charges that's not settled yet of my personal stuff.
So basically, you are invoking your Fifth Amendment right against compelled self-incrimination?
Yes, sir.
In other words,
thank you.
I'm not an
Yeah,
idiot. That's all he said. I am not a
Any parties
dummy.
wish to be heard on this issue? I think we've had argument already, but just in case there's anything else. All right. I'm going to advise both sides to file your proposed questions as essentially an offer of proof on what you would have asked Mr. Hall. But I am finding that he has a complete Fifth Amendment privilege here. I had earlier said that possibly he could talk about how Mr. Floyd
was
looked in
talking
the
low.
car, but counsel's argument is persuasive that that could provide a link, and since it's not, and accordingly I am gonna quash the subpoena. Anything else?
Drug dealer is out.
All right,
He doesn't have
thank
to
you.
testify.
We'll see if the jury's here, and if they're here by 9:15, we'll start at that time. Anything else for the record?
Yeah, and I just need to check to see if my witnesses have arrived yet.
Sure.
So if they're not, I just need a couple of minutes.
Absolutely. Just let Mr. Schaefer know, and
No, not grounds for a mistrial.
we'll shoot
No.
for 9:15 to reconvene, subject to your witnesses being here. All right.
Now there's no surprise there, right? No, the drug dealer is not going to testify, right? And you can't force him to say, I was in the car. So the state then comes back and says, well, here's your third degree felony murder charge. Also, the drugs in the car that you were in with the drugs. We're also going to charge you for that too, because it's you're in there with the drugs. So yeah, it's not happening. And like most of you in the chat said very plainly, right? You're not testifying. If you're that guy, you're not testifying. And maybe there may be some hardcore, citizens out there who would say, you know what? I'll take the third degree murder charge because I'm just that type of guy. It's not going to be me. And if I'm your attorney, I'm going to ask you to fire me because I'm telling you, don't say nothing. You don't know nothing. And let the state prove its case, period. So drug deal is out. Alleged drug deal is out. The defense is really chancing his arm. Chancing his arm here. Well, you got to do what you got to do, right? You got somebody else in the car. You want to you want to have that person testify that again they're trying to make the argument about Floyd and the drug use. Who's best to do it than the drug dealer? But the drug dealer is not stupid. He's got charges that he's already got to deal with. He's got charges for this case that he could deal with. The prosecution, they said, well, we'll testify, but to let the state give us immunity, right? The state can give me immunity for anything I say. They can't use that against me in a future prosecution. The state said no, right? They have the absolute right to say yes or no. They said no. If you testify, we're going to use that against you. So he's saying, I don't have to testify, and there we go. So the alleged drug dealer is out. It's too bad he's a drug dealer. Yeah, it's too bad he's a drug dealer. So that's where we're at right now. I want to see what happens later. The Star Tribune stream sucks. So I want to see. Let me try Sky News or let's try another one of these streams because the Sun. Let's see the Sun stream. I'm just trying to find another stream right now that's trying to see a stream that has good audio too, because the ones that we've been watching, the Fox stream yesterday was good, but everybody kept saying Fox, 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 Fox. We hate Fox. I'm like, oh my god, we hate Fox. All right, well, Fox 10 is always the best. Yeah, they're the best stream. We're going to use Fox. Hold on. All right, share screen. We're going to use the Fox stream, people. What can I say? If they got the best stream out there, we're going to use it. All right, I got some questions coming out. All right, so now since I've gotten the stream thing settled, does what next matter in the use of force? Floyd resisting, getting in the car. True. He was resisting. Reducing the restraint, putting in the car, you expect the force would come back. Yes. Maybe not. The thing is that, all right, so people have to understand with use of force, there's a difference between, so I can answer this question properly. There's a difference with the use of force, there's a difference between risk and threat. And this is important for everyone to understand when we talk about use of force, especially in police. If I, as someone who's almost 6 feet tall, if I'm going against a suspect who's 6'9", 6'10", right? There's a risk that person can overpower me, right? Or let's say there's two people, right? There's a risk that those people can overpower me. But I can't now use force because there's a risk. I can use more force only when there's a threat. So let's say if those people are starting to fight, put their hands up to start fighting me. That's a threat that I can stop with force. But if they're just talking to me, if I go there and they're just talking to me, hey, this happened, there's a risk, but I can't use force to prevent a risk. Now, that's exactly what you're hearing here in the Floyd trial. You're hearing the police officer and even the defense experts saying that they can use force to prevent risk, which is not true. You can't use force to prevent risk. And even the defense witness said that yesterday, right? We don't use force to prevent risk. We use force to prevent threats. Now, the difference between a threat and a risk, it goes fast. Sometimes somebody is not a risk, then they turn into a risk. Or somebody's not a threat, and then they turn into a threat. But in this case, when Floyd was resisting, let's just be honest, when he was resisting, he was a threat, right? He's resisting arrest. He's a threat to himself and a threat to the officers, as limited as he is with his handcuffs. When now he's on the floor and in a prone position and police are on top of him, he turns from a threat to now a risk, right? So now you can't continue to use the same amount of force to stop that risk because he's not really a threat. He's face down. You're on top of him. And when it became when he stopped moving, right, and passed out, then even though there's some risk that he can wake up and start flailing again, even though his hands are behind his back, so he can start flailing again, he's not a threat. So use of force, if that's the argument, that because he can wake up and be crazy, he's a threat, I mean, he's a risk, that does not justify using force against someone, because it's just like me going to a scene and two people, I pull out my gun and start shooting because they were a risk. No. Risk, you could prepare for threats, but there's a difference between risk and threat. And that's what the tension here is with the Floyd trial, between risk and threat. I know that was a long explanation, but that's really what the crux of this is coming to. Was Mr. Floyd a risk when he was on the floor, or was he a threat? Prosecution is saying he may have been a risk, but you can't use force. The defense is saying he was a threat that had to continuously be stopped. Whew, that was a lot. Sorry, I know I'm just speaking madness right now. Washington Post. Well, I found this other one. Fox 10 is pretty good. Park cop. Yeah. Now, another thing that's interesting about policing in most of these big cities, a lot of people don't know this, but when you're working for a city agency or city authority, when they hire security for their operations, they are called police. But if you worked for a private company, you'd be called security. So, for instance, here in New York, we have the MTA, which is the bridge and tunnel people. They hire security to protect the bridges. Those security people are called police, right? Because they're under state statute, they're giving power. We have security guards in hospitals, but since they're working for the state, they are called hospital police, and they have guns and go through academy, have training. I've actually trained hospital police. And the same thing. So even in this case, there's the park police. In the Floyd case, that's what you heard yesterday. We heard the park police. Now they have a policing agency just for their parks. We have that here too. In New York, we have a policing agency just for the parks, and they are known as park police. Now they have guns, they have body cameras, they even go through the same academy as the police officers, except they work for the parks department. So when we talk about law enforcement, it really, a lot of people just think about the cop on the street, but those cops are street cops versus this park police cop. And obviously, you help each other out. I've helped out NYPD. NYPD's come and help us, and we've gone to the state cops and helped them. So it's that type of thing. So understand, when you talk about police in most big cities, every different agency that the police have, they are considered police or peace officers. Some people call them peace officers, and you'll hear that in the trial testimony. Or you're a peace officer. You're a peace officer. I hope that explanation explains the park police versus the city police in Minnesota. Got a couple of super chats that came up. This one: drug dealers are accountable for killing our communities as abusive cops. This is very sad. Well, of course, I think obviously this guy's probably going to be going to jail. I think it's interesting though, and I think nobody's really talking about this. Chauvin could go to jail for killing Floyd, but then the prosecutors think about this. The prosecutors can then go and charge the drug dealer with third-degree murder, felony murder for the same death, right? For Floyd's death, because that's why he's not testifying. He's like, yo, even if you get the cop, you can just come take that dead body and bring him to my case and say, hey, this guy was the cause of death because he sold them the drugs. Crazy, right? So one body, you can have two people go to jail for murder, for felony murder, for the same thing. Insane. But yeah, the drug dealers are definitely killing the community. John says, I work exclusively in civil law, but it seems to me that there's a clash between the 6th and 5th Amendment here. Yes. Is there a concern that the jury will misuse the 5th Amendment invocation? Yes. That's why in the OJ trial, Mark Furman didn't give the 5th in front of the jury. And the reason why is because when you're up there and you say, I'm invoking my 5th Amendment privilege against self-incrimination, the jury, that most juries believe that's a yes, right? Or whatever the question was. It's the negative answer to the question. So for instance, if did you kill the guy? And you say, I invoke my 5th Amendment privilege. Most people think that's a yes, right? Because if it was a no, you would just say no, but it's a yes. So that's why. So they don't want to use the 5th Amendment privilege to believe that you're incriminating yourself anyway. So instead, they just don't let you testify, right? so they don't have to worry about that quandary. It's a legal principle. So yeah, the Sixth Amendment gives them the right, but you can't now force somebody else to testify if they have the right not to. So rules of evidence that doesn't allow it. But great question. But yeah, there's a conflict between the Fifth and Sixth, but it happens all the time. That's why Mark Furman, when he got up on the OJ trial and gave his Fifth Amendment, he didn't testify, right? Like, that's it. And Nate the lawyer, if the state charges the drug dealer for death after the cop charge, does they give the cop the ability to point to say, hey, the drugs were the cause? Well, that's what I think is going on here. Just I think that's a tactical game going on here. If they go and arrest and charge the drug dealer and prosecute, and the drug dealer goes to jail for the drug deal, then if I'm Chauvin's defense team, my first thing is saying they've already convicted somebody of killing Floyd, right? Felony murder, right? He sold him the drugs and the drugs killed him. That's the state's theory in that case. But in my case, they're saying I killed him. Which one was it, right? Reasonable doubt, right? It's reasonable to me. But the state is not stupid. They know they want the bigger fish to fry. We want Chauvin. We don't want the drug dealer. The drug dealer we got on other charges, right? So what they do is they'll say, we'll get Chauvin first and get him. And then we don't care if the drug dealer says, well, they said Chauvin. It doesn't matter because we got the drug dealer on a whole bunch of other stuff. We want the cop. That's kind of how this thing is playing out. I know that's going to rub people the wrong way, but that's just the reality of it. Let's get Chauvin so he doesn't have that excuse to say, look at they are saying the drug dealer, because that's essentially what they're going to do, right? That's essentially what we heard this today. The drug dealer is afraid because the state won't. If the state could give him immunity and say, we're not going to go after the drug dealer, right? To make it all on Chauvin. That would be easy, but they're not. They're saying, we're not going to let you get the drug dealer because we want Chauvin, right? And the drug dealer, as a consequence, we can get later. That's why you got to be careful about who you prosecute first in these cases, because it could backfire. And here, they're doing exactly what they want to do. We want Chauvin, so it is what it is. What steps are taken to avoid the jury from being tainted by the high level of politicization? Generally, they are sequestered, but here they didn't sequester the jury. So and they're just hoping that the jury avoids all media. I don't think that's going to happen. I think the jury, it's tough. They're going to sequester them to deliberations, so that's going to happen over the weekend. We should get closing statements, I think, tomorrow or Friday. No, we should get closings on Monday. And so, we might have a day off in between here and Monday. But it just is what it is. The jury, I think, are going to be tainted. And it all depends on what type of media you listen to. You listen to right-wing media, they're saying he's totally innocent. If you listen to left-wing media, they're saying he's totally guilty. And whether these things are convincing to you. But if the jury just sits there and looks at this case, it's I think the outcome may be different than what a lot of people expect it to be. So, but we'll see. We've been watching every day. We've been watching every day. Thanks for the 20 pounds. I appreciate it. 2 contributing factors, 2 contributing killers. Yeah. I know a lot of people aren't going to like this formulation of it, right? Because a lot of people, the states sit in the states. Let's just be honest here, right? The state's case is Chauvin's knee, or what Chauvin did, was a substantial cause of death for this guy, right? To George Floyd. But in this other case, potentially they're going to see Chauvin was it. They're going to say this drug dealer sold them the drugs was the substantial cause. So that's the tension. That's the tension here. Predictions. I'm not sure. I'm not sure what witnesses they got, but I know that I'm assuming the defense is going to probably go after some of the medical testimony, because let's not forget the defense has to stop one of 3 things. They got to show that this was justified, right? And that's what they tried to go after. This was justified use of force. If it's justified, then it's an acquittal all the way across the board. And they have to, and if they lose on that, they still can win on the cause of death. So I'm assuming they're going to attack both the cause of death and the justified use of force. So hopefully they'll have some medical expert come today and say, hey, he died of fentanyl overdose, right? He died of something else. And they have to remember they have to either show that he didn't cause this death, he wasn't the cause of death, or they got to show that that this was justified. They win one of those 2, they win. But it's tough. It's going to be tough. If this had been in New York and Chauvin wanted to hire you as an attorney, would you have taken? Yes, I would have. Of course. Yeah, I would have. I was taking him. No doubt about it. Do you think The disconnect between risk and threat with the officers in the heat of the moment is down to personal selection or training. It's down to training. It's down to training. But this was a fight that we got into yesterday on Twitter, where a lot of people on Twitter don't understand that. For instance, I was a gentleman yesterday on Twitter I was arguing with. A lot of people on Twitter thinks that it's what Chauvin, right? What Chauvin's intentions were at the time. That's how we judge the police use of force. That's not correct. That's wrong. The way use of force is judged in the United States is from the aspect of a reasonable officer facing the same set of circumstances with the information that that officer knew at the time. So technically, it is irrelevant what Chauvin's intentions were. I'll give you an example. Let's say a cop goes to a bank robbery, and going to the bank robbery, he says, you know what? I want to kill the bank robbers, right? I intend to go kill bank robbers today, right? So they go to the bank robbery, they get there, and there's a shootout, right? The bank robbers shoot at them, they return fire, and this cop kills 3 bank robbers, right? But now on the body cam footage, the DA sees that this guy is saying, yeah, I can't wait to get there because I'm going to kill think about 2 or 3 bank robbers, right? So he's got full intent. I intend to kill him. When I get there, and he kills him, right? Let's think about that. Think about that. So the cop is now going on camera, said I intended to kill them. So so now the DA puts the cop on trial, right? Even though he was there, he responded to a bank robbery, he intended to kill this guy. So we got him for intending to kill this guy. So let's pull back. The standard is not what this cop intended to do, but what a reasonable officer in his situation, facing gunfire from bank robbers, would they have returned fire? So the cop who intended to go kill the bank robbers, if his actions were reasonable, if a reasonable officer was taking those same steps, being fired upon by bank robbers and killed bank robbers, if that's reasonable, then no matter what that cop thought, you could not charge. So that's the way the law is in the United States. It's not the subjective beliefs of that officer, but it's what a reasonable officer. And that's why they call it the objective standard. It's an objective standard. That what that cop thought what his intent was at the time does not matter when it comes to whether the use of force was authorized. It's what a reasonable officer would do in this situation. And if his intent, no matter how bad his intent was, if it was reasonable and a reasonable officer would have done it, then he will not be held liable and he would have been justified. Oof. Oh, Rob Falou. Watching from my DA's office. Hey, yeah, this is my brother from law school. Better question. What would have been your theory of the case, Nate? It might have different from Nelson's. Different from Nelson's. I would have gone for the justified use of force, definitely. I'd have gone for the struggling. I would have definitely gone for the this was trained. I would have gotten the same expert, and I don't know what I would have done. I would have played a little bit more upon the drugs. I'd have really played a lot upon the drugs. I don't think Nelson, to be honest with you, looking at what Nelson is doing, I don't think he could have been doing a really better job because he's got a shit case. Think about how shitty this case is, right? He's facing 20 lawyers. He's doing all this, but I think where Nelson's failing is really in some of the cross examinations. He allowed those experts to just talk when they didn't need to talk. Now it's ridiculous. Hey Nate, just wanted to say thank you for making awesome
Good morning,
educational
everyone. We're
content.
going to proceed with the defense case. Mr. Nelson.
Thanks. Here we go. The defense case. Let's do it.
Thank you, Your Honor. Your Honor, the defense calls Dr. David Fowler.
So, as we said, they're going after now cause of death, right? Here's a doctor, and let's admit he's going to say Chauvin was not the cause of death was something else other than Chauvin, right? That's what we expect. I would be shocked if he doesn't say that.
Raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth.
I do.
You have a seat, please.
Thank you very much.
Our stylist for you, just in case.
Thank you so much.
Let's begin by having you state your full name, spelling each of your names.
My full name is David Richard Fowler. David, D-A-V-I-D, Richard, R-I-C-H-A-R-D, Fowler, F-O-W-L-E-R.
Mr. Nelson.
Thank you very much. Dr. Fowler, are you presently employed?
I am retired.
Okay. Could you tell the jury a little bit about what you did prior to your retirement?
Prior to my retirement, I have been full-time in forensic pathology since about 1986, which is when I first started training in that discipline. And I have been full-time within that discipline for 30 some years, whatever that number is.
Where did you work prior to retirement?
I worked at the Office of the Chief Medical Examiner for the state of Maryland.
Do you have any other employment either before your retirement or subsequent to your retirement?
Yes, I would do the occasional consultation case during the time prior to my retirement, and I have done some since my retirement.
Could you tell us a little bit about your education and background?
Certainly. I graduated from the University of Cape Town in South Africa in 1983. I did a year of internship in general medicine and general surgery. That's required in South Africa before
Now,
you can get a
obviously,
medical license.
This is their letting you
I
know
then
the
followed
witnesses.
that with a year
an
of
expert.
training in pediatric pathology at the Red Cross Children's Hospital in Cape Town. And completing that year, I entered a full-time 5-year training program at the University of Cape Town in forensic pathology.
And are you board certified?
I am. And so the system in South Africa is that you eventually graduate with a Master of Medicine in your discipline. So I ended up with a Master of Medicine in forensic pathology, which qualifies you in the South African system to be what they call a specialist, which in this country is the same as an attending physician, just different terminology. But that's equivalent to board certification here. When I came to the United States, I felt it was very important to get an American qualification if I was going to work in this country full time. And so I went back, and the American Board of Pathology demands that all pathology training is done in the United States or Canada. So, if I wanted to do that and be eligible for their examination process, I had to then go back and retrain. So I went to the University of Maryland for 2 years to complete additional anatomic pathology training to qualify me for that portion of the examination process, and then 2 years of forensic pathology training at the Office of the Chief Medical Examiner. I then took my board examinations through the American Board of Pathology in anatomic and forensic pathology, and passed those exams.
Great. So how did your career progress after you received all of that education?
So at about the time that I finished my training, I was recruited full-time into the Office of the Chief Medical Examiner as an assistant medical examiner. And that
What year was that?
I would have to look at my CV to be absolutely certain, 95 or 96, somewhere in that range.
Are you a licensed physician in the United States?
Yes, I am.
Now, you were educated in large part in South Africa, but then also here in the United States. Are there some differences between the degrees, or are they the same?
They're different letters after your name. But so if you go through the system, which is derived from the old British examination process, you end up with a MB, CHB, and some of them have different letters, which basically mean you have 2 bachelor's degrees, a Bachelor of Medicine and a Bachelor of Surgery. And it's a 6-year training program, not a 4-year training program like you have in the United States. Just different ways of getting to the same end point. If you want to work as a physician in the United States, you have to go through a process, which when I went through, it was run by the Educational Commission for Foreign Medical Graduates. and they make an assessment as to whether or not the university that you went to meets the appropriate standards. And these are all universities that are approved by the World Health Organization as meeting certain standards. Once you've been approved and your university is recognized, then you have to go through a set of board examinations, which are very similar to all US graduates graduating from a US university. So nowadays they are known as the USMLE examination. So we go through exactly the same process for evaluation. And then you can be, you can apply for a medical license in the United States based on that process.
This is
Okay.
important to show
Thank you
how
for
much of
explaining that. And in terms
expert
of,
he
just
is.
to clarify, you are a licensed physician.
Yes, I am.
All right. And
that's tough. Yeah, like,
you have board
are you a licensed
certifications
question?
in forensic pathology. And
you had to ask him
anatomic
twice. You had to
pathology,
ask
that's
him
correct.
twice.
Yes, I do.
And you worked as a pathologist or a forensic pathologist in the United States since approximately 1995.
So that's when I qualified or finished my training in the United States.
It's already getting
But I was
choppy.
working as a pathologist all the way from the time I arrived in 1991. So I've had uninterrupted work within pathology all the way from 1990, when I started my training in pediatric pathology at the
Interesting.
Red Cross Children's Hospital, which was probably back in 1985.
We'll be waiting for the question.
But some of that is training. So the question is whether you want to count that as being a pathologist or just a trainee pathologist.
What is a pathologist? How would you describe that to the jury?
Typically, the pathologist that most people will come across will not come across because they
That's what
work
they're
in a
doing.
laboratory in a
They're
hospital.
teaching. They're trying to teach the jury.
And they are the individuals who will run the laboratories. And those laboratories are the ones that take the samples which are taken from individuals during treatment by the surgeons and other clinicians, physicians, and do the analysis on those. So blood specimens, urine specimens, and then any biopsies or surgical specimens that are removed from an individual are analyzed in the laboratory by a pathologist. And that is the anatomic pathology training, as well as some of that is clinical pathology.
Can you tell the jury a little bit about your work with the Maryland Medical Examiner's Office?
Yes. So having finished my training in forensic pathology, I was recruited, became an assistant medical examiner, did that for several years, and then was offered the position of deputy chief medical examiner. And in Maryland, they have two deputies, one which is in charge of autopsy services and one which is in charge of statewide services. So the one in charge of autopsy services focuses most of their work on supervising the autopsy process and the staff that are doing that, as well as continuing to do autopsies themselves. Statewide services is the individual who then looks at the I was in that position when he suddenly passed away. So the health department asked me to act as the interim or acting chief medical examiner until they could find somebody to take the position permanently.
And how long did you act as the chief medical examiner?
So I was acting chief medical examiner for about a year. And after a national search, the health department appointed me into the position as chief medical examiner. So I believe that was 2002, 2003. By 2003, if I remember correctly.
I was
And you
talking to
served
my
in
daughter,
that capacity until your retirement?
and I muted the stream
Yes, it was
instead of
about
muting
17 years in that position.
myself. so
So what type of work is done at the
I'm like
medical
telling her, like, blah, 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 go do what
Explain
you got to
kind of the
do. I'm waving
differences.
to her. Yes, I forgot.
statewide
I'm
versus
sorry. I
the
muted the
autopsies.
stream instead of muting. Thank
So
you,
the
Secret
difference
Squirrel.
between what's done in the hospital and what's done at a medical examiner's
I
office is
apologize.
in the hospital, the pathologists are looking largely at natural disease. There will be some traumatic specimens come from trauma patients, but
Yeah.
most of what they're doing is looking at natural disease. The forensic pathologist is an individual who's gone on to do that additional training in wound patterns.
Yeah, no, I was
and
already
other
muted, but I muted the stream
non-natural
to
events that
talk. I
threaten
thought I was
life
trying to mute myself, but I
and
forgot I was
cause
already
death.
muted. So
So at the end of the process, you have the knowledge base of all the natural diseases that a general pathologist has, plus the additional training to evaluate how people die in unusual circumstances, sudden deaths while not attended, or any deaths which are traumatic. So that's the additional training. That portion is what's done at a medical examiner's office, are these sudden, unexpected deaths. And so the best way of thinking of a medical examiner's office is a 24-hour emergency medical institution. People die all the time. It's got to be available 24 hours. All of these deaths, you need to respond to them rapidly and appropriately in a dignified way. So it's a 24-hour emergency medical institution with the one responsibility at the end of the day of making a determination of the cause of death of the individual that has suddenly died.
In addition to your work at the medical examiner's office, did you also do some teaching?
Yes.
Where?
So I've taught at the University of Maryland.
So now I am muting his stream. You should be still able to hear me. I muted the stream because they're still going through, qualifications. Understand this too, people. This expert does not have to prove that George Floyd died of an overdose. They just have to throw enough doubt in the mix so the jury can't determine but through a reasonable doubt, right? They can have a reasonable doubt of what Floyd died of. So if this doctor says he died of this doctor says he didn't, that's what it is. So that's why I muted. I want to make sure we understand. This doctor does not have to prove George Floyd
So
died
for
of
a
an
portion
overdose.
of my career,
He just has to muddy the waters enough where the jury goes back to, we don't know what causes death. That means not guilty.
when a forensic pathologist trainee, what we would call a fellow, is doing a case, I would be directly supervising everything that they did on that case. And it would be my responsibility to ensure that that case was done correctly. And so it's almost like an apprenticeship, and they are standing, they're going to do the case, but you're going to be watching carefully and evaluating every single part of that process as they gradually grow through that learning curve to become a forensic pathologist. So for a while, I was hands-on actually teaching at the autopsy table. When I became deputy chief, I continued to do that, but one of the roles that was assigned to me was the residency director position for the office. And so that is the position where you supervise the residency program and how that program is accredited and evaluated by an outside agency. So you have to make sure that all of those requirements are done. So that's just an additional layer on top of that.
So were you responsible for recruiting the residents and things of that nature?
Recruiting, evaluating, bringing them in, and
Oh
then
yeah,
obviously
these shirts, the
training,
Walmart
evaluating.
shirts. I love
And
them
at the
too.
end of the
That's what I'm talking about, these
process,
shirts.
each of those fellows,
Thanks.
before
Thanks
they
for
can
the super
take
chat.
the board exam in forensic pathology, require that the institution complete a declaration that they have met the standards in order to practice. And that is before they can take the exam. So they are constantly evaluated daily, quarterly, and then at the end of the year to ensure that they have met the standards that we can attest to. So they are then qualified to take the examination through the American Board of Pathology.
And you,
This expert needs to look at the jury
you've
more.
testified in
Get that connection with the
cases
jury.
before,
Yes,
state and federal,
yes,
civil and criminal.
yes.
Can you estimate how many times you've testified in cases over the course of your career?
Gosh, over the 30-some years, it's hundreds and hundreds and hundreds of times.
Hundreds of cases.
Now,
Qualified
have you ever published
expert.
any articles or peer-reviewed journal type information?
both publications and presentations I've been involved. Publications, it has to be closing in on 100, but I haven't looked at my CV and counted them recently.
Okay. At the Office of the Chief Medical Examiners, do you review every homicide?
That was the policy, that the chief would get to review all homicides, all pediatric cases that were under the age of about 2 years, and then any case which the medical examiner could not determine the cause of death.
Okay. And how many homicides did you review?
Typically, the number of homicides in Maryland each year would vary between 500 and 600. So that would be the homicides alone. And then the other cases that added on to that would add an additional load of perhaps 50 to 100 cases.
Homicide means unnatural death.
So in this capacity, in this case, are you associated with an organization called the Forensics Panel?
Yes.
Can you just generally describe what the Forensics Panel is?
The Forensic Panel is a national organization that it looks at cases and does evaluations on cases in the forensic sciences, the medical sciences, and the behavioral sciences. So it's a forensic science organization that looks at those particular issues.
What is your role with the Forensics Panel?
I am a forensic pathology consultant.
In terms of the Forensics Panel, what's unique about how that organization operates?
So the Forensic Panel really started the process of peer review evaluations in order to ensure that the case was diligently evaluated, objectively evaluated.
He's trying to talk
was
to the
based
jury. If you
in
notice, he's looking
the
at the
known
jury,
science.
not the.
So that's
person asking
the first
questions.
thing. It's peer review.
Which is
and
good.
has
That's what you
evolved
want
over
your
time.
witnesses to do.
Then
Make
it's
that
an
connection.
organization
Make
which
that connection with the
has
jury.
many different disciplines recognized or that are recognized working within it. So
But he's a
it's a
professional witness, so he
multidisciplinary
knows
team.
what he's doing.
So you have experts in all sorts of medical fields that can be assigned to the case depending on the nature of the case. It's an independent organization.
Is it similar to what's called an M&M conference?
A mortality and morbidity is what you're referring to.
Yes.
That is
Yes, he
something
would.
very similar.
Yes, he would.
That happens in the average hospital when a patient may have something adverse happen to them, not necessarily fatal. That's the morbidity part, and or it is fatal, mortality. And in those circumstances, physicians will present in a closed environment all of the materials and their evaluation, and the general physician population that have gone to that conference can sit down and critique it, evaluate it, and it's an opportunity for self-evaluation, learning for people, and quality assurance for the hospital program. Yes, it's similar.
How did you end up working within the Forensic Panel, and when?
About 15 years ago, I was approached by the Forensic Panel, and they indicated that another forensic pathologist had recommended me as somebody who might well fit their program.
And so within the panel there, you described it as a multidisciplinary approach. How does that function?
So depending on the nature of the case, the Forensic Panel will assign individuals that have skills in areas that the case apparently needs from an evaluation process. So,
and you're compensated for your time?
I am.
And your hourly rate?
It's $350 an hour.
You at some point became involved in this case, State of Minnesota versus Derek Chauvin.
I did.
And how did you become involved in this case?
The Forensic Panel, I was approached and asked to become part of it. And I felt that this was such a complex and difficult case that this would better fit working through the Forensic Panel than trying to handle this case independently. So I referred this case to the Forensic Panel.
And you were approached by me, correct?
I believe that was the first conversation I had. Yes, that
Right.
was a while back.
And you referred
It
me
was.
to
It
the
was.
forensics panel.
That's what he asked.
That's my
he did ask him
recollection.
that.
Yes.
Thanks for the $5.
Now, in terms
Changing
of this
things.
particular case, how many of these peer reviewers were ultimately involved?
There were 13 peer reviewers
Oh, I
across
see.
multiple
Funny.
disciplines that were involved in this case.
How is it useful for you to have those peer reviewers involved?
True.
Well, several of the peer reviewers, I believe 7, are forensic pathologists. So my direct colleagues with the same training and skill set that you'd expect a good forensic pathologist to have. There were additional individuals in behavioral health,
I don't know if Kim Porter's going to be charged.
pulmonary,
They got to let him get it all out,
pulmonologists,
right? I'm the best
emergency room
doctor, the
physicians,
most qualified person on the planet,
toxicologists
and
that
here it
were
goes, right?
present as
So
part of
that's
the
what they're going
evaluation
through.
team.
They got to build him
because
up.
They have the
So
detailed
the
knowledge
jury
in
can
those
say,
other areas
this guy is an
that
expert
really
and I
helps
trust his opinion
critique any
over the
opinions
others.
that I may form and provide their expertise in ensuring that everything
Yes,
was
they
looked
pay for their
at
experts.
and that any opinion that is expressed is based in science.
What's the process that you apply in approaching a case
I would.
such as this?
It's like you got to let them go through this.
So
right?
the
judge can't tell them,
primary
unfortunately.
reviewer
So,
in a case like that will be provided all of the available information that has been given to the forensic panel.
that's a
They
risk
will
they're
go
taking.
through that material, study it, evaluate it, and then the peer reviewers are given a similar but sometimes slightly less onerous package of materials, but they are given similar materials. They will go through it, and then I would, in this case, as I did in this case, I've been a review pathologist on several, and in this case, I was the primary. I will do a presentation to the forensic panel. And during that time, they have the opportunity to evaluate and critique my opinion. Based on that, if there's additional information that is necessary in order to help refine the opinions, that request can go back to the forensic panel and through to whichever attorney, whether it be a prosecutor or a defense attorney, a plaintiff's attorney, or a defense attorney. Requests for the appropriate additional information can be made, and if that information is available, sent back so we can complete and try and ensure that we haven't missed anything. So there may be several reviews along the way, and then at some point, if the
Objection, Your Honor, to the narrative nature of the response, and could we, Your Honor, approach the bench?
Sidebar.
Yeah, I didn't hear that, but I didn't hear what the objection was. But this is starting to get a little dry. Like, what the hell's going on? Let's get to the point here. Is it normal for the defense case to be so much shorter? Yes, because the defense doesn't have to prove anything. The defense can just sit there and say, we're not doing anything. It's the prosecution has to prove their case. So they just have to take and point holes in what the prosecution is saying so to blow them up, right? So that's why their case is definitely going to be shorter. If they had to prove something, then yes, it would be probably as long, if not longer. But here they're saying we don't have to prove anything. Now in the OJ case, it was unique because the OJ case, they had everything, they had their own forensic team, so their case was longer than the people's case. But so that happens when you got the money. But generally, you don't have the money and resources to do as much as the state does. But at the end of the day, yeah, and that's what they're doing here. You just have to do enough to poke holes in the other side. Nate, you taught me about Tennessee v. Gardner. Thanks for that. Yeah, I've been saying that for years, right? For all my other police videos, it's all been talking about Tennessee v. Gardner, Graham v. Connor, but now everybody's seeing why that's so important. It's funny because I know a lot of you who've been watching me, right, have been hearing those cases all the time and been thinking, okay, but now you see in the real world, that's what they point to. Graham v. Connor, Tennessee v. Gardner. Every police officer should understand these cases. I don't think they do, but they should. Secret Squirrel. His actual testimony is going to be 5 seconds. Well, he's going to say he died of this, he died of this. It wasn't Chauvin. Like, we know what he's going to say, right? He wouldn't be testifying for the defense if he's going to say Chauvin killed him. So we know. It's just how's he going to say it, and it's going to be convincing. Here we go.
Yeah, not sure whose that is.
All right.
Boston,
Dr.
right, this
Fowler,
sounds so boring.
are you
we go.
familiar with NAME?
Yes, I am.
And what is NAME?
NAME is the National Association of Medical Examiners.
And are you a member of NAME?
I am.
Have you held any leadership positions in that organization?
I have, yes.
Can you, well, let me ask you this. Does NAME have an inspection and accreditation process?
Yes, it does.
Or committee, I should say.
Yes, it has a committee which does that particular
Remember
task
that
for the organization.
the People's Medical
What is the
Examiner was the president
responsibility
of
the
this.
inspection and accreditation committee?
To evaluate medical examiner and coroner officers. It's a voluntary program. And basically, it means that the medical examiner's office, once they've passed that evaluation and been accredited, have met certain standards that the National Association of Medical Examiners Board of Directors believe are appropriate for the office to have in order to ensure the safety of
My
both
stream
the
is
staff
live.
that work in the
It's
office
a live stream. I don't know.
and also the community
As
that
much
they
as it
serve.
can.
Are you a
rest
member
as-
of that committee?
This is what
I
it's
am
on
now,
Fox
and
10
I
now.
was
So.
a previous
Oh.
chairman of that committee.
Does NAME have a standards committee?
It does. Right now, they are two separate committees.
And-
Previously, they were both inspection and standards were under one committee. At the time, I was the chairperson of that. I chaired.
And
the
how-
entire- but it's
how-
now been separated off into two separate ones.
Gotcha. How are the standards approved?
So the standards are different. As I said, the accreditation checklist is approved by the board of directors. The standards are a grassroots process where any member of NAME can suggest a standard. That is then put out to the general population of members of NAME. And then those are discussed and voted on at the annual general meeting in the business meeting.
Yeah, this is
And
true.
so therefore, anybody,
Civil defense has to
hundreds
prove
of
its case.
pathologists
They
that
have
are
to win.
present at that
But
meeting can
in
stand up and address and debate those particular
in
standards.
criminal cases, the
And then
defense
at
just
some
has to
point,
tie.
a
The
vote is
defense needs to
called
tie. Tie is a win
by
for
the
the
chairman
defense.
of the standards committee as to whether or not that standard would be included or not. And so therefore it's approved by the general membership, not by the board of directors.
And one last question before we move on. When were those standards approved?
The initial standards started out in 2005, and then they get updated on a regular basis because medical knowledge changes, and therefore one needs to keep them appropriate and fresh.
Can you tell me generally what a death investigation is and what it involves?
Yes, a death investigation is very much like any other medical examination, but specifically looking at individuals, obviously, who have died. So there is gathering of information from the scene of the death. And that
Now,
is somewhat
if you guys are bored
to
watching this
replace the
today,
information
just imagine
that a
these
patient
jurors
would
who
give
watch
to
this
their
crap
doctor when
every
you
day.
walk into
Just imagine how
the
they feel.
examination room, your doctor, the
Right?
first question they'll ask you is, why are you here today?
It's very dry.
Deceased people can't speak. And so therefore, the scene information really replaces some of that information. You gather the scene information, you gather past medical records, you then start gathering information from all sorts of pertinent sources. That will be the ambulance or EMT run sheets, the hospital information if the person made it to the hospital, the current medical information, the past medical information. There'll be witness statements, there will be police records, videos, everything that is available and pertinent will usually be gathered as part of that process.
Would it also include things like specimens that are collected?
Yes, so if a specimen is taken in the hospital, that will be taken. If clothing is available in the hospital and removed from the person during resuscitation, that may well be gathered as well. All and everything that is reasonably available that could potentially define how the case may be evaluated at the end will be gathered as is reasonable. So yes, hospital specimens. If a person, for instance, went into surgery and a specimen was removed from them during the surgical procedure to try and save their life, that would also be requested. So there's lots of things that you would try and get.
And is there then ultimately it
this guy's
results in a
killing
death
me.
certificate?
Well, there's a long process which goes on before that.
How
This
long
guy's
is that
killing
process?
me.
So the process would include an autopsy, which is an external examination of the person, an internal examination of the person, maybe x-rays of the person, CT scans of the person, depending on the resources. And
Look at all these
and
messages in this
needs
chat about how
of the
bored
case.
everybody is. This is
Additional
this is
specimens
why
will
they
be
always
taken
say
at the
you
time of
gotta.
autopsy,
It's not just about the
look at
information,
under the
but how you
microscope
present it.
and
This is
send off to a
boring.
toxicology
But
laboratory.
he may have
I'm
something to say,
talking
so we
very
gotta
generally. Every case is going to be different.
you gotta wait.
At the end of that process, you begin the evaluation of the case. In complex cases, certain specimens will be retained and often sent to an expert in that particular area. So some officers have access to a neuropathologist who specializes in looking at brains and spinal cords. So if you have that resource and it's a case where that really may well assist in getting the additional detail that a specialist who only looks at that can provide, then
This is on direct
you'll say that
examination. You're
specimen
not
then
able
looked
to
at,
ask leading questions.
in conjunction with you. So it's usually an examination of the two with that extra expertise at the same
he's a little
time.
bit more boring.
Are there other factors or
Yeah,
other
good money,
processes
baby.
that occur?
If you can make
Yes,
it.
and some officers have access to cardiac pathologists. The Maryland office does. And so in many of these complex cases, the heart would be retained and examined by a cardiac pathologist. And you have in fairness, the general forensic pathologist has a substantial body of knowledge and is very good at identifying most things. But there are cases when somebody who only looks at that one organ is going to have a better eye for detail in that particular area. And so you can do that. Not all officers have access to those resources, but if you have, that's a good thing. So those all add time to waiting for those examinations to be done and the results to be sent back so they can be put into the evaluation matrix and the jigsaw puzzle of all of the information that you're trying to include, as well as the toxicology results, which take a while to come back, the microscopic examination, which the pathologist will do themselves. It takes a while for the glass slides. So some cases can take 2 to 3 months. And NAME actually has a requirement that you should complete 90% of your cases within 90 days. Otherwise, you cannot be accredited. They prefer you to do it within 60 days, but 90% of cases should be completed within 90 days. That's 3 months. And the 10% of cases that aren't completed with it are going to be very complex cases. Often the deaths in custody and the pediatric sudden deaths are the ones that fall into that 10%. So they often go out even further as you gather all of that information.
Just so
Thank
people
you.
understand, this was
So,
called laying the
can
foundation
you
for his opinion.
explain
Right?
what the death certificate is?
They're laying the
ultimately,
foundation
a death
for his
certificate is
his
issued,
opinion.
right?
How are you qualified to
Correct.
make this opinion?
And can you explain what the death certificate is?
So the death certificate is a document that is produced by a physician. The greater majority of them are signed out by physicians within the hospital or nursing home, etc., when people die of natural deaths. Medical examiners are usually exposed to about 25% of deaths within their jurisdiction.
See, and notice how
So,
who he's looking at when he's
Death
answering.
certificate is a
Looking toward the
certification
jury,
that the person has died, and within a reasonable degree of medical certainty,
using hand
the
gestures.
certifying physician believes that whatever is on the cause of death line is the cause of death within a reasonable degree of
It's a
death.
So let me
professional
ask you, in
witness.
terms of this particular case, you've reviewed a
Here we
substantial
go.
amount of information.
Now we
Yes.
get the question.
Can you just briefly describe the information you've reviewed in this case?
Gosh, it goes on for several pages, but there are past medical records, the records that occurred in the hospital at or about the time that the attempted resuscitation of Mr. Floyd occurred. There are ambulance records, there are police records, there's toxicology information. There are multiple videos from multiple sources, both body-worn cameras, surveillance videos from stores, and other facilities in that area. There was video material from observers that is available. There's the toxicological data, there's the autopsy information, the autopsy photographs, the microscopic examination. It goes on and on and on. There is a substantial amount of information on this case.
And before we kind of get back to the death certificate in this particular case, upon your review and based upon your training and education, your experience as a forensic pathologist, have you formed opinions in this case to a reasonable degree of medical certainty?
Yes.
We'll come back to those shortly. So in terms of the death certificate, are there two parts to that?
Yes.
And can you explain those two parts?
So the first part is what the physician believes to be the cause of death. So that is something that you will put what we call part one. That's what the CDC refers to it. The death certification process is one which is controlled and governed by the CDC, although each state will have a slightly different format to their death certificate and the way they do things. The guidelines that are put out there by the CDC for completion of death certification are certainly ones that are national.
So what's the first part of the death certification according to the CDC?
Well, the first part is the primary cause of death.
And what's the second part per the CDC?
Other significant conditions contributing to death, but not directly related to what's in part one.
Now, I'm going to like to show Exhibit 193, which is already in evidence. You see that in front of you and ask to publish. You're familiar with this document?
I have seen this document, yes.
And what is the first part of the certification of death?
So the first part here, the cause of death, is cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression.
Now, under that, there's a phrase that says underlying. Is that what you're talking about in terms of the second part per the CDC?
No, the way the CDC normally phrases it is you can break it out into multiple lines. So it could be cardiac arrhythmia due to such and such, due to such and such. And so that's where the underlying conditions come into the death certificate. At least, when you look at the CDC guidelines and the death certificates that I'm used to completing. The second part that I refer to as part two on this death certificate is called other contributing conditions.
And what are the other contributing conditions that you review here?
So on this particular death certificate, the certification says that atherosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use are considered contributing conditions.
So this was prepared by Dr. Baker, correct?
Yes, that is my understanding, that he was the individual who certified this case.
So in terms of Dr. Baker's analysis of this case, how did the heart and drugs contribute to the cause of death?
they were significant, or other they contributed to Mr. Floyd having a sudden cardiac arrest, in my opinion. That's how I would read it.
Okay. So I'm going to take this
Okay.
down.
They contributed.
If we could unpublish, sorry.
Isn't that what
Doctor,
it
did
says,
you
though? I don't-
prepare a PowerPoint presentation to walk through your opinions in this case?
Oh, we get to see the
Yes.
PowerPoint. This is going to be good. Let's see the PowerPoint.
Judge, I've identified this as demonstrative exhibit 1098, and I'd move to publish.
In objection to 1098 for demonstrative purposes only.
That means it's not
It
going to
is
go into the
received for
back
that
with the
purpose
jury.
alone.
So demonstrative means they can show it right now,
So,
but the
before
jury won't
we,
take it back in when
begin,
they're deliberating.
Doctor, can you summarize briefly what your opinions are in this case?
Yes. So, in my opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerotic and hypertensive heart disease, or you can write that down multiple different ways. During his restraint and subdual by the police, or restraint by the police. And then his significant contributory conditions would be, since I've already put the heart disease in part 1, he would have the toxicology, the fentanyl and methamphetamine. There is exposure to a vehicle exhaust, so potentially carbon monoxide poisoning, or at least an effect from increased carbon monoxide in his bloodstream, and paraganglionoma, or the other natural disease process that he has. So all of those combined
That kind of
to
confused me a little bit.
cause Mr. Floyd's death.
All right. So let's walk through
What? All
each of these, if we could.
Now he's going to make me sit up in my chair
Starting
because I'm like,
with the
what is
opinions
he
of
talking
Dr.
about?
Baker as far as the cardiopulmonary arrest.
I don't know.
Before we
He
do
just
that,
lost me
if
a
we
little bit
could
here.
publish,
He's saying everything caused
the
it, but
exhibit,
it's like,
Your Honor.
I don't know. He was by carbon monoxide.
Can you just describe what this is and why it's relevant to this case?
So this is a document that is produced as a guide for medical examiners to use when certifying the death, and specifically the manner of death.
What is the manner of death?
So the manner of death is, how did the cause of death come about? And you have 5 different choices that you can check off or write down on a death certificate as to the manner of death.
Now, does this document specifically address asphyxial deaths, positional asphyxia deaths?
It addresses all sorts of manner of death. And again, it's a guideline put out there to assist medical examiners. And unfortunately, not every case cleanly fits into one particular category or meets the criteria for the guidelines.
Okay. So let's talk about, in terms of this second slide, positional restraint. How does NAME deal with the autopsies
I don't know.
and death
I don't know if
investigations
that's
involving
true.
potential positional restraint?
So the recommendation is that, what's our recommendation? They say you may.
I don't know.
be
Reasonable
classified
doubt
as
is not any
homicide.
doubt. So let's go through it.
Doesn't
Maybe
say-
there might be
doesn't say
something. I
shall.
don't know.
Or should. It says may be classified as a homicide. Again, we have to recognize that these are medical guidelines. And it then goes on, and everybody, I think, can actually easily read that. If you want to go back one, and in such cases, there may not be intent to kill, but the death death results from one or more intentional, volitional, potentially harmful acts directed at the decedent, without consent, of course. Further, there is some value to the homicide classification towards reducing the public perception that a cover-up is being perpetrated by the death investigation agency.
Now, in terms of the 5 manners of death that you described, again, we've heard testimony, or the jury has heard testimony from other experts who've testified. There's homicide as one, suicide. Can you describe the others?
So homicide, suicide, accident, natural, and then undetermined.
So this next slide, can you describe what undetermined means according to the guidelines?
So according to the guidelines, undetermined, or the other term on some death certificates is could not be determined, is a classification that's used when the information pointing to one manner of death is no more compelling than one or more other competing manners of death, in thorough consideration of all available information.
And the guidelines also define homicide.
Yes. And again, homicide occurs when a death results from a volitional act, in other words, an act a person did, committed by another person to cause fear, harm, or death. Intent to cause death is a common element, but is not required for classification as a homicide. More below. It is to be emphasized that the classification of homicide for the purposes of death certification is a neutral term and neither indicates nor implies criminal intent, which remains the determination within the province of a legal process.
Why is that second part important?
Because this is a medical opinion that is on a death certificate. The manners of death are unique, or virtually unique, to the United States of America. These were put on the death certificate by the Center for Disease Control in order to gather information as to how Americans died or die for epidemiological purposes, and to study and try and prevent deaths. They are not meant to usurp any kind of legal process. And in fact, in many circumstances, regardless of what the medical examiner puts on a death certificate in the way of a manner, the legal system can and will act in a completely independent and different format.
Okay. Now, again, we discussed a little bit about the CDC death certificates, the instructions. Is this the guideline by the CDC?
Yes.
And it is to enter
I'm
all
listening, but
diseases or
it's like he's
conditions contributing to
losing
the
me.
death
And
that were
that's
not
the
reported
tough
in the
part
chain
about
of
this.
events.
In
It's
part
just-
one, in the first,
I'm tr-
in the
it's-
first part, yes.
I'm following, but it's just
Now,
it's,
back
that's just
to
not keeping my
and
attention. I'm keeping my attention here
keep
because I
this
want
down for a moment,
to
Your Honor.
listen so I can give good feedback. But this is not.
So with
something I'd be
respect
watching.
to Dr. Baker's autopsy,
Okay, here we go. Now we
I
get
just
to
want
the
to talk a
question.
little bit about the cardiopulmonary arrest that he references.
Okay.
What are the findings that were relevant to your analysis in this particular case?
There are substantial pertinent negatives in this particular case that drove my opinion.
What about the size of the heart?
So there are, again, certain pertinent positive issues. Mr. Floyd's heart was enlarged. There are multiple methods and studies that have been done on the size of the heart in the United States. There's one study out of the medical examiner's office in San Antonio, Dr. Molina and DeMaio, where they took a series of individuals who died suddenly with trauma and hopefully eliminated, as part of that process,
Now, if you guys remember,
natural
they've
disease
already
that might
talked
have
about the
caused
enlarged heart,
alterations in the
why it
heart
was
size.
enlarged, why it wasn't.
Excuse me, doctor.
So-
Did you prepare a slide relevant to this, and if we can publish
Yes, I
it?
did.
Okay.
Yeah, let's get to the slide. We
So the Molina study you were referencing?
Right. So in their study, they found that 95% of males had a heart weight of between 233 and 383 grams. Anybody outside of those limits, and you would expect about 2.5% to be lower and 2.5% to be higher. That's the 95% certainty on either side of the mean. And so that is what they proposed as being the reference range for adult males.
Now, how about the Mayo study?
So the Mayo study is one where you can go in and calculate the weight based on the size of the individual, which is potentially more accurate, because you don't really want to take 130-pound, 5'5" male and say, and plug them into a particular range. You'd expect their heart to be smaller, as most of their organs would be smaller. And Mr. Floyd was a very tall, robust-looking individual. So I would expect him to have a larger heart. And so the type of study, such as the Mayo study, where they put in the sex of the individual, male, the height and the weight.
It's hard for us to understand
and then
him, but easy for us
come
to
out
understand
with,
the other ones.
as part of that calculation,
You lose. So
counting for that,
it's got to just be
the
very
95th
adjustable.
inclusion rate
You've got to make
would
it
top
easier for
out
us
at
to understand.
510 grams.
We're not doctors, right?
In this circumstance. So Mr. Floyd's weight at heart weight at 540 is outside this range.
Okay.
I will tell you, there are multiple studies. There's another one out of Chicago and Northwestern University, which has even broader range and would indicate that Mr. Floyd was within the 95 centile, but still right up at the very top end of normal. Bottom line is he has an enlarged heart.
So some studies say it's normal,
unpublish
some
this, Your
studies say it's not. So what is he saying here? Some studies say that
So
his heart
in
was
terms
normal.
of-
Some say it was normal.
That's what you ultimately
So-
kind of see as relevant evidence here is that Mr. Floyd had an enlarged heart.
Yes.
Based on some studies, because he just said, based on other studies, it was within normal range.
How
So
does the size
I'm
of
not
the
getting it.
heart affect the blood supply, nutrients, oxygen, things of that nature?
The heart is a muscle, and it's dependent on
Yeah,
the supply
I would be
of
probably better
oxygen,
to say about that.
glucose, and
I think
other
Floyd had an
important
enlarged heart,
nutrients
but
to function.
based on what study?
When a
We're just using
heart or
studies that
any
say
other
it's
muscle
enlarged, or we're using studies that
grows
say
in
it's normal,
size,
or,
its consumption of those
I
vital
don't know if it's
components
reasonable doubt.
increases. So Mr.
people are
Floyd's
throwing around that
heart
term.
would have
We said it's 1 and it's really
twice the
1.1
need
is
of
reasonable doubt now.
those nutrients
Okay.
compared to a 260-gram heart or 270-gram heart, which would be halfway.
That would be
right
that
in
would
the
be one of my
middle of the
questions
Molina
on
study
cross.
criteria.
You're not a cardiologist, right? You're not a toxicologist,
Because there's just
right?
twice
You're not
as
this, you're not
much
that. Again,
heart
limit the
muscle
damage, right? Limit the
to
damage.
support
He's an expert. He's not an
and
expert in
each
what
of
he's
those
talking
cells
about.
is
That's
bigger
where I would
and
go with the expert.
requires more oxygen.
So it's kind of like the law of supply and demand, right?
Correct.
All right. What happens to a person when they experience like a lack of supply, so to speak?
So like every other organ, the heart has certain reserves of energy built in. The
He
typical
specifically said there are
amount
studies out
of
there that says
reserve
it's within
in
the
our
average
brains
range. Within the average range.
is enough for us
On the
to
high end
maintain
of average, but
consciousness
he's
for about
within the
10 to
average range.
15
So I would
seconds.
say I would be
And that is
comfortable
the
saying
organ
above
which is
average,
most
but
sensitive
there's some studies that
to
says it
constant
was
supply.
within the average
The
range.
heart
So
or the
No,
brain?
the brain.
it's
The heart
interesting.
is the next. But like other organs, it will be able to maintain function even when the supply is reduced or even completely cut off. But at some point, you do have to resupply because those reserves are, when the heart is being
it's possible. When you
exerted,
have many different
are
studies,
being used.
I'm just saying you're
you
more
either have to
accurate, but this
completely
one says
replace them,
you're right.
or
Maybe that's the
if
one
you
you
only
believe is more
partially
accurate,
replace
so.
them, at some
I don't know.
point, you're going to exhaust the reserves.
So how do we replenish the supply, so to speak?
The replenishment comes through the coronary arteries, and they bring blood into the heart. As that blood arrives,
So they're going after the
delivers
90% blocked
oxygen
arteries.
and other nutrients, and it also removes the byproducts of the metabolism of those heart muscles as they contract.
So what type of symptoms might someone who show if they are diminished in their supply?
So at some point, there are a variety of symptoms that can result. You can feel your heart racing. You may even get palpitations. You get potentially short of breath. And in some circumstances, you may start getting chest pain, what we refer to as angina. And it can get even worse than that. You can have sudden symptoms such as a collapse without any warning. But there's a spectrum of different symptoms that can occur.
So when the supply isn't being met, what would a person customarily do to replenish the supply?
Well, when one becomes short of breath, you tend to relax, ease up, back off, stop walking, stop running, stop exercising until such time as you feel like you've got your heart rate down. Some people monitor their heart while they're exercising to ensure they don't go over certain limits. So there's different ways of doing it, but typically, if you experience symptoms,
Yeah,
it's
he
your
said
body
carbon
telling you,
monoxide,
slow
not
down.
carbon dioxide.
And what happens if someone doesn't do that?
If I remember correctly.
If you don't, and you don't heed those warnings, or you can't heed those warnings for other circumstances, the consumption of those those essential metabolites goes on. The production of the products of contraction, which need to be removed, continues to increase, and at some point, the heart will fail, go have a sudden cardiac arrest / arrhythmia. That's what you expect to see.
So, I mean, within the field of forensic pathology, what would you call the stopping of the heart?
We typically call it sudden cardiac arrest or cardiac arrhythmia.
What's the difference between sudden cardiac arrest and arrhythmia?
A sudden cardiac arrest really is an observational situation. You observe the person suddenly stop functioning. And usually the background process is an arrhythmia of some sort, often starting out as a relatively benign arrhythmia and then progressing into
This is sometimes
more
when you're watching a
malignant
live
arrhythmia, which
stream,
then,
right? It's just this is what it is.
decreases the function of the
Waiting
heart
for them to
and
get
eventually
to
the
it.
heart fails.
So what types of things might cause a heart to be bigger like Mr. Floyd's?
The commonest one in the United States, which is part of the developing world, is hypertension, what we would call essential hypertension. It just happens.
So he's
And
tying everything together.
Based on what you
which is good.
reviewed, did you determine whether Mr. Floyd had hypertension?
Yes.
The size of the heart would be extremely good evidence that he had hypertension.
Hypertension.
Secondly,
Larger
there
heart,
are medical records
clogged
that I
arteries.
did see where he had an elevated blood pressure at previous hospital administrations or previous clinical interactions.
Now he's tying.
So yes,
things
there's
together.
evidence that
Now
he
he's tying
had
things
that.
together.
And then there was
Finally.
something else found at autopsy, a tumor that is sometimes associated with hypertension as well in certain people.
That's a paraganglioma.
Paraganglionoma, yes.
Anoma, sorry. We will talk about that a little bit later. So just kind of generally, can you describe the major blood vessels of the heart?
Yes, there really are two major blood vessels, the right coronary artery and the left coronary artery. The left coronary artery, within a very short distance
Yeah, that was
of coming off the aorta, divides into two major arteries, the left anterior descending and the left.
That was an extremely high
circumflex.
blood pressure.
So some people call it three coronary arteries, but technically there are two with one dividing into two. Neither description would be incorrect.
And what is narrowing or stenosis of the arteries?
So narrowing or stenosis of the
High
arteries
blood
means that
pressure,
the arteries,
enlarged
lumen,
heart.
the inside diameter
Blocking the
of that
arteries.
artery,
You see where
is
we're going
smaller
with this, right? We see
than
where
it
we're
should
going
be.
with this.
it has been narrowed by a disease process.
Or you're a cardiologist, so that's what's going to come
How
out.
does
but you see where we're going with
long-term
this.
drug use affect narrowing of the arteries?
Drug use
There are certain
to
drugs
the arteries.
that
He's
do
walking us through it.
cause
He's walking us through it.
advanced or more rapidly advancing atherosclerosis. Not just drugs, but many substances and toxins, even smoking, for instance, is associated with earlier atherosclerosis. And certain drugs and other drugs, substances, can be added onto that particular list. So even urban pollution has a risk of advancing heart disease.
And what specific drugs?
We're going to hear about
in this
fentanyl.
particular
We're going
case,
to hear about methamphetamine.
methamphetamine, which was present in Mr. Floyd, has been associated with earlier onset of narrowing of the coronary arteries by atherosclerosis.
He's chaining everything
And
together.
can you describe the difference
Drugs,
between
heart.
proximal and distal narrowing of the arteries?
Beautifully.
Right. So the narrowing
Put it
can
all
occur
together.
anywhere up and
Let's
down the
just-
artery.
Smoking.
When it occurs close
use.
to its origin, i.e. close to the aorta where the blood supply comes from, we will call that proximal. If it occurs far down the artery towards the end of the artery or further down the artery, it's called distal. The implications are somewhat different. And if you have narrowing close to the beginning of the artery, anything
I would be
downstream
shocked to
from
not
that
hear the
narrowing
question. You are
is
not a
subject to
cardiologist, right?
decreased supply
I would
of
be
blood.
shocked if I don't hear that.
If you have it further down in distal,
So here
then the
we'll see.
first part and all the branches that come off the first part are supplying that
I
heart. and
might
that
even
part of
ask
the
him
heart will
if we
still
want to know
receive
exactly how
enough
this works. The
supply.
best person to speak to is a
It's not
cardiologist, right?
restricted. But once you
Make
get
sure
to
you know. I
beyond
want
the
to make
narrowing,
you got to really throw because you had a cardiologist
tissue,
session.
heart tissue,
This is
muscle downstream
pathologist.
from
So
that
now you want to say, well,
is going to be
if you really want to know what's
subjected
going
to a
on,
reduced
you
supply.
talk to a cardiologist. So that's where I think.
And so in this
if I was
particular
cross-examining.
case, he had significant narrowing of all of his coronary arteries close to their origin, which really is consistent with all of his heart, unfortunately, being subjected to reduced supply, not just a portion of his heart, but the entire heart.
Is there a certain amount of narrowing that forensic pathologists consider to be enough to cause sudden death?
So the typical
Anything over
conventional
75%. Watch.
number that forensic pathologists use is between 70 and 75%
Boom.
narrowing is a risk factor for sudden cardiac death.
Can you
Floyd was at 90.
survive with greater than 75% narrowing?
Of course.
Oh,
you can.
absolutely. I have seen many, many cases where
No.
it
Show
can
me-
be
show me.
90, 95%. Again, it depends
Taking a stand
where
for Chauvin
on
is
the
a death
artery it
sentence.
is.
That's he'll get destroyed.
So proximal narrowing is more dangerous than a distal narrowing because only part of the heart. And in this particular case, we know Mr. Floyd had 90% narrowing. So he was walking around with 90% stenosis beyond the 75. And that was not affecting him as part of his daily activities. So when he was at rest, walking around, doing his normal daily activities, I know of no information that he was symptomatic.
So
or
hit
having
that
any
like button.
problems. So yes, you can go beyond 75%.
Let's do it.
That's why cardiologists may conclude you could survive with greater than 75%.
Yeah, so I think the difference is that medical examiners see people who've died with 75%. And cardiologists see people who are walking around with 90%. So they see the live population, we see the dead population. And so we probably end up with different standards based on, unfortunately, that's what we see.
Yeah.
So in terms
I
of
agree,
an
Dave.
autopsy finding, can you describe what myocyte necrosis is and whether that's necessary to diagnose a sudden cardiac death?
So myocyte necrosis is both something you have to visualize it microscopically. You have to look at the individual heart cell. The myocyte is just a word which is heart cell. You can infer that there may be myocyte necrosis at autopsy if you see bleeding into the heart itself.
Mhm.
But it is a microscopic diagnosis, and it is not necessary for myocyte necrosis to be present for a sudden cardiac death.
So someone who has a sudden cardiac death may not have myocyte necrosis.
Correct.
Why might that happen? Why might someone not have that myocyte necrosis?
See, as a lawyer,
Again,
you're trying to tell a story, and
the heart goes
you
through a
can't lose-
process
you
of
can't
dying.
lose us within the story. I
It
think
takes a
he's doing
while
good
for
job,
a heart to die and for the actual myocytes to start showing the changes that we can see under a microscope.
but it's like watching a
We-
comedian. You got to
we
get
need
to
to
the punchline
understand that-
eventually.
That's why you can do heart transplants.
Mhm.
is somebody who has been injured or suffered some other catastrophe to their brain and is brain dead and is a donor, their heart can be removed, put on ice, flown across the country, and put into another person without any damage to that heart. And that process takes hours.
Okay.
So if the death is rapid, you will not see myocyte necrosis. It's the time frame from the heart stopping. So the time we typically see myocyte necrosis is going to be somebody who has had symptoms and survived for a period of time, so that that process can advance to the degree where we can see it under the microscope.
Okay. Now, you've kind of talked about sudden cardiac events. Let's talk about the arrhythmia. Can you describe what is called the conduction system of the heart?
The conduction system of the heart is a very important part of the orderly contraction of our heart.
So,
We have two chambers which receive blood from the body, the atria,
so right now he's
and then we
not.
have two bigger, very muscular
I don't
chambers,
see. Like, we got to start talking
ventricles
about
that
Floyd.
pump
Why?
blood
Then-
under high pressure.
I don't know. Maybe
to
he's
the
just
body.
building it up.
And so the way the heart works
Tell me
is
how.
it's
Tell
a
me how this will work with Floyd.
two-chamber on
Did he die from a heart attack?
each
Did he die
side.
from overdose?
One
That's
side
what I want
supplying
to
the
hear. I
lungs and the
understand
other
what he's
side
trying to explain
supplying
to us, but
the
you're
body.
losing me. Tell me why he
Where
died.
the atria contract and push blood into the ventricles to
Talking
fill
to the
them up.
jury now.
And then the ventricles contract
Okay.
to push blood to the body. The ventricles are very powerful, and there's a valve in between them to stop the blood flowing back.
Mhm.
So what you need is an orderly contraction process where the atria contract first, followed by the ventricles. This is coordinated by the conduction system. And we have in the heart what is known as the cardiac
yeah.
pacemaker. It's a generic term.
Part of
but it's
trial
the
work
little piece of
is
modified
the
heart muscle
presentation and being able to
that actually
present, no
has
matter what your
almost
facts are. You
nerve-like
can't present them in a
function.
Does
cognitive
it have
way
a
that
name?
keeps everybody
It's called the
interested and
sinoatrial
people
nerve.
can follow. Then you lose.
And that
So I'm
generates the
I'm not saying
initial
he's not giving good information.
activity
I want to get to
which
it.
causes the atria to start contracting. And between it and another node, which is at the junction of the atria and the ventricles, called the atrioventricular node, there is a little bundle of modified heart muscles that conduct that
Yeah, let's
down.
not forget this is a professional witness.
And then there are
This is a
further
professional. All of them are professional witnesses. Right?
modified heart muscles that go down to spread the impulse, the electrical impulse to the heart to cause it to contract.
What are those called?
That's, it's the bundle of His, Purkinje fibers, etc. They will have medical terminology, but basically it's modified heart muscle cells. So what that does is
Modified
the
heart
sinoatrial
muscle
node
cell.
fires,
What is that called?
and the impulse is conducted down
Mhm.
the fibers to the AV node. At that time, the atria
He's really
contract.
the one thing though. I'm
forcing
going to
blood
say
into-
he's
At the
really
time that
risking
the impulse
the whole.
arrives
You're not a
at the ventricles,
cardiologist question,
that
right?
node then fires
Because we've been talking about the
shortly
heart for
after the
almost 20
atria,
minutes now.
and the heart
That
contracts and
question
sends
is
the
going
blood
to be
on its
David,
way.
right? You're not a
you get
cardiologist,
this
right? If we wanted to
orderly
know,
Double beat to the heart. You can hear the valves opening and closing, atria first, and then the
I mean,
ventricles.
would
and
any of you
that's the
guys ask
sound
that
the
question?
physician
Because
listens
that's
to
my first
when he
question.
puts a
Are you a
stethoscope over your heart.
cardiologist? Because we
That's
had a
like
cardiologist.
the blood pressure?
Sorry?
Is that blood pressure or?
So the blood pressure is actually generated by the contraction of the ventricles. That's the essential output of the heart, is directly related to the volume and the pressure of blood that is pushed out of the heart.
Okay. So what happens if this conduction system gets impaired?
Then you don't have orderly contraction of the heart. And so if they fire at the wrong time, then if you had the atria and ventricles firing at the same
If
time,
need be.
you would
Yeah.
move no blood.
He's not a
The ventricles
cardiologist.
are
First,
very
I'd get him to
powerful.
admit he's not a
They
cardiologist.
slam
You
that
want the
valve
two-
shut.
Yeah, if you want to know really what's going on,
The atria
as
fire at
he
the same
said
time, they
earlier, you
can't
speak
force
to a
blood
doctor who
past it.
specializes in
And
this,
so you've got no blood
cardiologist.
to
The
fill the
cardiologist
ventricles.
is saying this.
And is that
So, yeah.
an
So
arrhythmia?
that's
That's an
that's
arrhythmia.
the problem
So
sometimes.
there are multiple
We're
different
getting too
types of
deep into the
arrhythmias
details if
that
it's not
are
just
documented.
specialty. But I
And,
don't know what they're going to do. That
What can happen? Well, can sudden death happen as a result of an arrhythmia?
Absolutely.
This is true. But if you really want to know the details, you go.
So which artery supplies the
I wouldn't go to,
pacemaker, the SA
a dentist
node
may know
that
stuff
you
about the heart.
described?
But if I really want to know what's going on, I go to
The
the
sinoatrial node is supplied by a small branch that comes off the right coronary artery.
And did you review, again, the autopsy and observe findings relevant to Mr. Floyd's right coronary artery?
Yes, so unfortunately, that was the artery which showed the greatest degree of narrowing,
Which was how much?
90%.
Does that increase, or that type of narrowing increase the risk for sudden death?
Yes, in that if and when the blood supply needs of the heart on the right
Well,
side
you need to get a certain answer.
increase, and
from them.
that's
You need to
also
get a
going to
certain
apply to
question
the
and answer.
sinoatrial
So
node.
even though this is slow,
Are
you're
not
waiting for the
met,
bomb to
that
end at the end.
sinoatrial
And
node
you'll
will
usually
not
see that at the
function
end. He's going to
properly.
ask a question. It's
And
just like,
the
boom. That's what you're
will not
messing
fire
with.
properly, and
Just
you will
getting
end up
there
with
is the
an
problem.
arrhythmia of some sort.
But I think he's doing a good job
So
explaining.
essentially, if it
But we try to get to that.
misfires, there's no pacemaker.
Here's the whole
Or-
point to all this.
That is correct, yes.
How does exertion come into the analysis?
Exertion basically increases the demand for oxygen throughout the entire body, mostly because of the muscular activity. So as we exercise, our heart rate and our breathing rate normally compensate
Oh yeah,
to increase the
when
oxygen
you got it on video. it's generally a
that we're
home run.
bringing into the body.
The
through
defense.
respiratory
I don't think
system.
any rational
Increase
person would think
the
the
amount
defense
of blood,
didn't have an
the
uphill
amount
battle
of
with this,
oxygenated
right?
blood, which is being
It just
distributed
does,
to
so.
the body.
Maybe you're right.
And
Maybe
the
I
way that increase of
but the defense had an uphill
blood,
battle. and
the way
I'm
the
just
body
pointing it out.
increases the blood supply
Sorry.
is to increase the rate of the heart. So we will go from our resting heart rates, which are somewhere between 60 and 100,
When someone
We'll
sees
push it
that
up
he
to
interacted with someone, killed
120,
them on camera,
140,
essentially killed them on camera.
150,
It's
depending
hard to
on
overcome
the
that.
degree
So
of
it just,
exertion.
it just isn't the
And
nature
beyond,
of
it
what we're
gets
looking
dangerous.
at. You know?
So essentially, the
Now it's
more
about proving
exertion,
it.
the more oxygenated blood is needed.
Yes.
How do drugs like methamphetamine come into play as far as the, in terms of the conduction system?
So methamphetamine is
I'm thinking it will.
dangerous at
I'm
several
thinking it
levels
will.
in this particular
Because
case.
of the nun case.
One, it
And
has
we'll talk about that break.
known arrhythmogenic potential.
But, yeah.
In other words, it sensitizes the heart to arrhythmias. It makes, it's just been documented that people on methamphetamine have an increased risk of an arrhythmia. Secondly, it increases the rate that the heart beats at. As a stimulant, it pushes the heartbeat rate up. So therefore, the heart is now going to demand increased oxygen, the heart muscle itself. And thirdly, it is a vasoconstrictor.
What is a vasoconstrictor?
So a vasoconstrictor is a substance which causes blood vessels, usually arteries, to narrow. And it's physiologically important, and it is protective in certain circumstances, but can become dangerous in others. And the way a vasoconstrictor works in most circumstances is to act on the muscular layer that's present in arteries. Arteries have multiple different layers, and there's a muscular layer in there, and it causes that muscular layer to begin to contract. A little bit of contraction, that's good. Too much contraction, and it can slow down the blood beyond what is necessary. And even in certain circumstances, you can stop the blood by giving a vasoconstrictor substance.
Okay. So in this particular case, we've got an enlarged heart, right?
Yes,
We have a heart that has narrowed coronary arteries, right?
yes,
And based on your review of the video evidence, you observed a pretty significant struggle between Mr. Floyd and the three officers.
correct.
Methamphetamine on board, which is a vasoconstrictor.
Yes.
Have you or your colleagues ever certified a death due to the atherosclerotic cardiovascular disease?
Yes, it's a unfortunately, very common cause of death
And even at these levels of narrowing, 75 and 90?
Anything above 75%, as I previously mentioned, meets the criteria for enough narrowing, at least within the community of practicing forensic pathologists.
Okay.
Have you ever performed an autopsy sort of expecting one cause of death but finding another?
That's why we perform autopsies. It is a thorough internal examination to identify anatomic deviations from normal. And so therefore, your preconceived notion, a common, I wouldn't say a common example, but we see it every now and then, would be a motor vehicle collision, where somebody has multiple injuries, and you look at them and go, okay, they've got enough injury there to kill them. But when you go in, you can see evidence that they had a stroke or a heart attack. And that's what potentially caused them to lose control of their vehicle at the time that they had and got all their multiple injuries. And so then we sit with the issue of, do we put the heart attack under part 1, or do we put the heart attack and or the stroke type findings under significant conditions? Because obviously they were driving their vehicle, but it may have caused them to lose consciousness.
No, he didn't.
You know, so
He's read the
these
report.
are just dilemmas that we face as to where you put things on a death certificate. And sometimes you're not right and you're not wrong.
How about hypertensive cardiovascular disease? How does that relate to a cause of death?
We're trying to figure it
So,
out, but
again,
I'm assuming they're going to say it
there
wasn't
are a
Chauvin.
number
That's what
of
I'm assuming they're
sudden
going to,
cardiac
but he just
deaths
haven't gotten to it yet.
that
So
are
he's trying to
related
explain
solely
why
and
he's saying it's not
exclusively
Chauvin.
to
So,
the
you know, I think
increased
we need to
size
be
of the heart.
cognizant of what he's trying to say.
And so those are the ones that, since hypertensive disease is the most common cause of an enlarged heart, we would typically use that as the cause of death and say hypertensive cardiovascular disease.
Have you ever certified a death due to hypertensive cardiovascular disease?
Yes, I have, multiple times.
Have you diagnosed both hypertension and coronary artery disease as a cause of death in combination?
Yes, and again, that is probably even more common because a significant proportion of the population have hypertension, so their hearts are enlarged. And as you get older, you tend to lay down deposits of material in your arteries. And so there's often both are present in many, many cases, unfortunately.
Now, again, in terms of hypertensive cardiovascular disease, we talked earlier about kind of the struggle between Mr. Floyd and the officers getting into the squad car. How does that type of exertion play into hypertensive cardiovascular disease?
It increases both with the hypertensive and the atherosclerotic, it increases the demand and the stress on the heart. And the more the individual is stressed, both physically and in other ways, the more the demand on the heart is going to increase.
So in terms of stress, right, how does that affect the heart?
So we have certain innate stress mechanisms built into us, reflexes built into us. It's called the fight and flight reflex, is the common terminology that you will see within the medical literature and also within the lay literature.
Turn it up a little bit.
And
Thanks.
this is a mechanism where if you are in a stressful situation, it prepares your body to be able to cope with the stressful situation. And what happens generally is the sympathetic part of your nervous system begins to act. That causes secretion of adrenaline as one of the examples, and perhaps other catecholamines, which are substances that are part of that sympathetic nervous system. And adrenaline causes some of your blood vessels to constrict. It's another potent vasoconstrictor. The idea being that you don't need to digest the food in your stomach, for instance, while you're in a very, very dangerous environment. So it really shunts the blood, pushes the blood to the organs that are more important: the heart, the lungs, the brain, your muscles. It also shuts down the blood supply to your skin. So it does all of those things. But it also speeds up the heart to increase the cardiac output to maintain oxygenation of the brain, your muscles, and other things, so that you can have an additional reserve to fight that threat.
All right. Now, so the fight or flight kind of that you described, it increases adrenaline, right? It causes the heart to beat faster. Agreed?
Yes, and yes.
And the adrenaline, how does that come into play? Did you say that was a vasoconstrictor?
So adrenaline is a vasoconstrictor, yes.
Including the arteries?
Oh, yes.
And ultimately, what does that do potentially?
So it narrows the arteries. And again, we have smooth muscle in the cardiac arteries. So there's a potential of the adrenaline and the methamphetamine further narrowing those arteries in the heart, as well as arteries elsewhere in the body, restricting blood flow.
Now, in terms of that kind of stress reaction, I would like to craft this question carefully. The jury saw some evidence, which I know you reviewed as well, of an incident in 2019, about a year prior to Mr. Floyd's death, where Mr. Floyd was stopped by the police, was seen or believed and admitted to ingesting some controlled substances at that point, and was subsequently seen by paramedics. Do you recall that information and the information you reviewed generally?
I did.
And at the time that he was initially seen by paramedics, his blood pressure was taken, and if I'm not mistaken, it was 216/160. What does that signify to you as far as this stress relation?
So a high blood pressure like that, and that's markedly elevated, could be due to his hypertension being out of control. But this is much higher than I would expect. Secondly, it could be part of the stress reaction where adrenaline is being secreted and it's pushing his heart rate up, and that will increase your blood pressure. And if adrenaline is secreted, it's also causing vasoconstriction. So there's more blood staying within the central vasculature, and so therefore that will also increase your blood pressure. There are multiple explanations for that, but certainly stress would be one of them.
Okay. Your Honor, I believe that right now would be a good time for our mid-morning break.
Minutes, let's reconvene at 11:10.
Okay. All right. So we got a lot out of that, but I need coffee after that. I'm just going to be honest with you guys. It was tough to watch. It was tough to watch. That was tough to watch. I'm all for experts, but my God, you get to the, you got to give me something to work with. So obviously they're trying to tie everything together, right? Hard. So you're hearing them tie everything together in a very slow and methodical way. But I always say this: better to entertain than bore, right? And the problem is that I think maybe they didn't have enough time, but it's not easy enough for. I think it's hard for me to follow. But I think it may be harder for people, especially if this is not your expertise. You're using a lot of language. It's not, it's not sexy testimony, but it's just not great. It's just not great. I understand where they're coming from. Nate, do you think there might be a tactic here, closing in contrast to facts and evidence of the slow burn defense? Yeah. I think that might be the case. But I'm just trying, I try to understand where we're going with it, because I think this doctor, I want, we know what we want to hear him say, right? We want to hear him say A, B, C, and D, and the reasons why. It seems like they give us the reasons why, before they give us the conclusion. So I would have rather said, here's the conclusion, and here's how I got there, right? Blah, 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 blah. So, they're walking us through a lot, but it's just like, it could just be overload where they give you so much information. It's like, I don't know what's going on. And when you got an expert, it's dangerous because you could force the jury to rely on the other experts, right? Well, I don't know what this guy was saying, but this guy was very clear to me. So, it's a risk. It's a risk. Like the lawyer. When you were a cop, did you ever punch a guy so hard that his brains came out of his ears? Asking for a friend? No, I've never punched anybody. No, that didn't happen. We got into some scuffles, but it's nothing like that. Oh man. This was interesting. There's a point of contention that I want to bring to you guys while we're waiting before I read some coffee too. One of the points of contention is the eggshell plaintiff rule, right? And what am I talking about? So I'll go full screen for this so we can all understand. You take the victim as they are. So a lot of people are saying, well, if Floyd had a heart attack, he died of a heart attack, or Floyd had a drug overdose, he died of a drug overdose, he died this, he had that. That would absolve the defendant from being guilty of killing him, right? So it's more or less, think about this scenario. If, let's say, they beat him up, but a regular person, a regular healthy person would have survived. That's essentially what this doctor's saying. Someone who was healthy in George Floyd's position would have survived. That's what we're getting to, right? Just want to make it very clear. We are getting to that point, right? A healthy person would have survived this encounter. But George Floyd was so beaten up. His heart's bad, high blood pressure, that's the reason why he died. So, but for his horrible condition, he would still be alive. That's the eggshell plaintiff rule. So, we call it the eggshell plaintiff, but the crumbling skull, right? But generally, in American law, you take the victim as they are. So if the victim, I don't know if you guys ever watched, what's the movie with Mr. Glass, where the guy had a special bone condition where if you touch him, his bones break, right? So if somebody's slapping that guy could, give him a skull, give him a skull fracture, whereas slapping somebody regularly wouldn't. So if you slap somebody and you kill them, then, you take the victim as they are. You can't say, well, if he was a stronger person. So here's a case. I want to bring this up to you guys. Here is a case from Minnesota, right? Where they have it. Yeah, we're talking about Unbreakable. But here's a case from Minnesota. It's called State v. Nunn. It's a felony murder burglary case. But I think it's important so we can see. It's from 1980. It's the Minnesota Supreme Court. And, is this it? No, it's the wrong screen share. So let me go back. Let me screen share. State v. Nunn, 1980. So I want to show you this case because I think this is important. So everyone here knows what we're looking at when we go forward, right? And everybody understands this principle because it seems like a lot of people are confused about this when we talk about it. So I want to make sure. Okay. So in State v. Nunn, I'm going to read this. This is the relevant portion of it. The state. Now Nunn was convicted of felony murder, and he was appealing his conviction, right? But they didn't. It was all good. He was all good. So he was convicted, and that was it. But here is the relevant part. The state at trial proved that the defendant and two other young men unlawfully entered the estate carriage house in which the groundskeepers of the estate lived, and that while looking for property to steal, they were surprised by the sudden appearance of the tenant, whom they severely beat. So right now we got the tenant surprised them, they severely beat him. This beating, while insufficient to cause death to a healthy person. So their beating wouldn't have killed somebody, and it wouldn't have killed somebody, right? If you were healthy, you would be good. Precipitated a fatal heart attack in the victim. Evidence against the defendant at trial included testimony by the defendant's accomplices and evidence that the defendant and a friend had burglarized the same carriage house and stolen money from it earlier that year. Now, in this case, this defendant was convicted of murder, right? Even though the beating and the injuries were insufficient to kill a regular person, this person had a heart attack. That's what we're talking about here. And that's what I think people have to understand, right? That's what people have to understand. So, this is what I like to consider called the eggshell plaintiff rule on display, right? people have been convicted of felony murder using the eggshell plaintiff doctrine in Minnesota. So we're all clear about what's going on. Nate, the lawyer, if George Floyd had survived, would you go after Chauvin for attempted murder? Asked earlier, sorry if I missed it. I don't know if you go after him for attempted murder, because then I would just say it's just an assault. But no, I don't see, because you need a little bit more intent. You don't. I think this murder charge is susceptible because of the death, right? Since we're talking about felony murder, if he didn't die, then we really just have an assault, right? So you don't have any murder or even attempted murder because he didn't intend to kill. I think when you have the death, then you don't have to prove they intended to kill. You just have to prove the death was a result of the actions. So I don't think you'd have I don't think they would get an attempted murder. I think they would have assault though, for sure, like a higher level of assault. Yeah, good question, Joseph. Nate, can you charge a cop with attempted murder? Yes. But I think in these circumstances, I don't think you get him with attempted murder. I just don't think there's enough there because it's an inchoate crime. So yeah, I don't think you have enough for attempted murder. But I think because we're really talking about the result of the action. So there you'd have to prove that he intended, he went there with some intention, and unless they were just so reckless, maybe you can get it. But I think that's a harder charge to maybe you can get it, but I don't know. I don't think I don't know if I would charge it. But again, that's for their laws may be different from what I'm thinking about, but attempted murder on an assault. If he survived, then you got to prove, maybe if he'd have shot him and the shooting was, I don't know. I don't think attempted murder just fits with the way these facts are. I don't think this fits. I just don't. Well, I'm going to get some coffee because that guy is putting me to sleep, and that's why. So I'm gonna get some coffee. Oh, let me put this on the screen. So I'm gonna get some coffee. I'm gonna use the bathroom. Then we're gonna be right back here. I think they said they'll be back in 5-10 minutes. So I'll be back. Hold on. We're going through this again, and then on the second piece of it, we're going to be starting to try to look at how the prosecutor is going to cross this guy. I expect to, again, if I'm the prosecutor, I want to narrow the focus, right? I want to narrow this expertise, right? You're a pathologist, right? You're talking a lot about the heart, But if we really want to know about the heart, we'd speak to a cardiologist, right? Yes, and go into that thing. And then, and then you also have all this other testimony of all these other doctors that you can also use. Well, Dr. So-and-so, is this true? Is this true? Is that true? So, you can really, really, really see some questions developing on cross. And obviously they already have his report. Nobody's going to talk about. So they've already got their questions prepared. And we want to make sure it's yes or no answers, right? Because you got to handle these witnesses. Remember, we saw the defense. They let the expert talk a lot, right? They let the expert talk a lot. Here, you don't want the expert talking. You want to just doop, 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 doop. R.I.P. Nate, what did I do? It's funny because one thing before I go and get my coffee, one of the more interesting things is that after I did the Hunter Biden video, like all my videos after that started to be like demonetized, so every video I did after the Hunter Biden video, demonetized. So I sent it back to YouTube. I was, giving the YouTube to check, and they've remonetized it. But after I get all the views, right? I get all the views when the video come in, and now it's remonetized. Oh, thank God, YouTube. Thank God you demonetize it. But it's just interesting how they like Hunter Biden did boom, 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 boom. Everything's demonetized. Like my yesterday's stream. But they've thank God they've started monetizing my stuff back again. But it was just funny, just like everything after that, no matter what video it was, demonetized. All right, I'll be back. Go get some coffee, guys, because this is dry testimony, and I gotta use the restroom. So I'll be right back. All right. They're not back yet, but I'm back with some coffee. Ugh. This is good that at least we can watch the case. Somebody sent me a super chat. Another one of these, huh? Eddie Oliver. Thanks for the super chat. Nate, when you're a cop, did you ever karate chop a bad guy? Starting at the top of his head and split him completely in half. No, didn't do that. But that'd be cool to watch, though, to be honest with you. That would be cool to watch. It was funny because I remember when I was on patrol for a while, I was like the arrest guy because I was good at the arrest processing. So it was weird though, being like because I was an officer and I had to train like my superiors, like some of my supervisors who hadn't taken arrest before. And it's just a weird process. But I just at a point I've had so many, it was like crazy. Then when I did the investigations, I had a couple after that. It's just insane. But yeah, it's I don't know. It's interesting. It was an interesting life, and I enjoyed it. I enjoyed when I was a prosecutor too. I enjoyed when I taught at the law school. So it's been and now I enjoy private practice. Private practice is pretty interesting. It's a little bit more. It's a little bit different because it's how do I say? It's not about private practice, especially being a defense attorney. It's more about what's best for the client. And I think when you're a prosecutor and when you're in law enforcement, this is what's best for society. Sometimes that means letting the defendant get off, right? Sometimes that means letting the defendant being not guilty. If that's justice, the prosecutors are supposed to see justice, not conviction. So I think that's like the big difference from working for the government than working for private practice. Because right now it's about what's best for my client. Sometimes that's not justice. Justice is not best for my client. Just like I think with any criminal defense attorney sometimes. So I'm assuming, everybody knows this cop. Let's just this I say cop, but this guy, this expert. I'm assuming we all know what he's gonna say, right? Like I'm just waiting. I'm waiting for him to say fentanyl killed him or something like that. So, but we'll see. We will see. Let me do this. YouTube has been treating me bad lately. I think I've been a bad boy. It's funny. YouTube, I call YouTube the boss because it's true. They are the boss. All right, boss. Here we go. Boom. Now, this stream is demonetized. They just want to make sure to keep me on my toes, right? But I'm telling you guys, after I put that Hunter Biden video out, they've been like on me, like, yo, demonetize everything and make everything get rechecked by humans. That's my YouTube life now. Oh, I'll change my focus. I don't have autofocus on. Hopefully it's me. That's on me. Yeah. That's on me now. Sorry. Thank you. Got to change that autofocus. I don't know. I'm thinking this expert, he's doing a good job, but he's just not doing a great job. Nate the lawyer just got here. Yeah, the lamp. Yes. Lamp and baby spoon. We're going old school today, Fiona. We're going old school. Fiona's a doctor too. So get your behind up in here and let you explain some of this stuff to us. How long? I wonder how long we're gonna have to wait for this. Toothbrush in the coffee date with this is somebody new to the stream. Yes. Toothbrush in the coffee. I bought baby spoons for my daughter, but now she's too old for baby spoons. It's funny because I'm the only person who uses the baby spoons. I just think they're just so much better. It gives me the perfect amount of sugar and able to stir. It's just, and why am I gonna throw them away? They're useful. So no clickety clacks. Why no talk about the ex-girlfriend holding her chest and she said he's sick? Oh, no. I think that's all relevant. Yes, no, yes, that is relevant. That's important. That's important stuff to say, right? This is important stuff. No, changing things. You are correct. That is important stuff. No doubt about it. But it's, totality of the circumstances. So, but yeah, no. This is yes. I think the girlfriend's testimony helped the defense a little bit. I do, especially with some of the stuff she was saying. Yeah. So, Nate, when you were a cop, did you ever rip a bad guy's still beating heart to show him? Ask for a different friend. I think Eddie Oliver. Hey, I appreciate the super chats, but two things, just to be clear. I didn't when I was in law enforcement. I never did anything to anyone that caused them to go to the hospital. I remember have I had suspects have to go to the hospital? Yes, because somebody might have had hypertension, may have not had taken insulin, things of that nature. So that has happened before where someone's gotten sick. But yeah, I've not been in an incident where I've actually hurt somebody. I tried specifically not to.
Just a reminder, Doctor, you're still under oath.
Yes, Your Honor.
Here we go.
All right, Dr. Fowler, right before the break, we were discussing Mr. Floyd's heart and the contributions of Mr. Floyd's heart to his death. Did you form, in your opinion, to a reasonable degree of medical certainty, which you thought was the principal cause of Mr.
Here's the
Floyd's
bomb.
death?
Yes.
And what is that?
Cardiac arrhythmia due to hypertensive atherosclerotic cardiovascular disease during restraint.
Okay.
Now, in terms of the other contributing factors to Mr. Floyd's death, did you, as a part of your review, make other considerations to things that may have contributed?
Yes, I did.
I'd like to discuss with you carbon monoxide, or CO. Okay. You've reviewed all of the videos in the case, correct?
I did.
Did you pay attention to where
No
Mr.
problem, bro.
Floyd's head was
Thanks
positioned
again. I think they're
relative
funny
to the squad
questions.
car?
Yes, I did.
Which way was his face, nose, mouth facing?
His face was facing towards the vehicle, towards the rear of the vehicle, and directly towards the area where you would expect the tailpipe or tailpipes of a vehicle to be.
Remember all those questions earlier about the
And let me
tailpipe?
just ask you, are you suggesting that Mr. Floyd died from carbon monoxide poisoning?
Absolutely not. No, not a full carbon monoxide poisoning. No.
All right.
Okay.
Now, I'd like to, if the court could publish, and before the court does, the next slide.
That's
has a
reasonable. Be the
screenshot
change. You're being very reasonable.
from
That's reasonable.
Officer King's
That's
body
not
worn
crazy.
camera at 20:24:09. Do you see that in front of you there?
I do not at this time. No.
Okay.
Yeah,
How about now?
Yes.
I don't know. I don't know why they mentioned him coming up. Again, he's got to tie it together.
Your
Give him a
Honor, I
chance. Give him a
have
chance. He just
independently
started.
marked
Give him a chance.
This single slide as Exhibit 1058. And based upon discussions with counsel, I'd move for its admission.
Any objection?
No objection, Your Honor.
1058 is received.
Permission to publish? Dr. Fowler, based on your review of the videos and evidence, were you able to determine if the vehicle was running?
There was evidence that the vehicle was running.
What would that evidence consist of?
What I observed was a collection of fluid. I don't know if this is working. Maybe I'm doing the wrong way. Collection of fluid.
That's carbon dioxide. We're talking about carbon monoxide, CO, not CO2. Okay, they're going to talk to the judge. You know what? It's Chauvin is like taking some serious notes. It must be, this guy's 19-year career going through the trash. Horrible mistake though, but it's sitting in that courtroom every day must be terrifying for that guy. But it must have been terrifying for George Floyd too. And I do want to be honest with everybody. At the end of the day, this all could have been avoided if the guy just sat in the car, right? So it's sad. It's sad. The whole chain of events are sad, So, but resisting arrest, and it's funny because we even have the case now in Minnesota with the whole resisting arrest, right? Somebody resisting arrest. It's tough, It's tough. And, this goes into the thing about police use of force. You try not to make mistakes. Nate the lawyer, how do court reporters do their reporting these days? You know what? They still get money. You still some courts you still got stenographers typing everything out. You videotape the whole thing. They're unnecessary now. You can literally videotape the whole thing. I know some states do that now, but
Objections overruled.
they're unions, so you can't just take people's jobs. Unfortunately, well, fortunately you can. Yes, Nate. Need two clean communities.
Dr. Fowler, based on your general knowledge as a forensic pathologist, your personal experiences, what comes out of a car's exhaust?
Yes.
Typically, we see the products.
That's also true, Michael. Michael's right about that. Checking the bell instead of calling the
coming
cops.
out the exhaust. And the major products of combustion are going to be water vapor, carbon dioxide, carbon monoxide, and then a couple of other very small other particulate and minor gases that come out of the exhaust pipe.
Is carbon monoxide toxic?
It is an extremely toxic gas.
How does it act as a poison?
Carbon monoxide attaches to the hemoglobin in our red blood cells, and it attaches to those red blood cells more tightly than oxygen. So it competes for the same binding position on the hemoglobin that oxygen does. And since it is a better, and it binds more firmly, the oxygen can't displace it.
Well, the defendant
So
has the
as
right to hear
the
everything the
percentage
judge is
of
saying to
carbon
his attorney, right?
monoxide
So if
bound to your
that's why he's
hemoglobin
getting
in
even
your
a head
bloodstream
start.
slowly goes up.
Physically, he might not
You
have been able to go
lose
up
that
there
portion
generally, but
of
he
your
could if he wanted
oxygen
to. And
carrying
here they're just
capacity.
saying, yeah, give him a headset
So
so
if
he
you
can
have
hear it. It's
10%
his trial. He's
carbon
on trial.
monoxide
He should get
saturation in your
all
bloodstream,
information if he wants to.
You've lost 10% of your oxygen carrying capacity.
Okay. Can that cause ultimately death?
When you get to levels way in excess of 50, 60%, people typically, even young, healthy individuals, will start to die. The issue is that people with significant heart disease and reduced capacity in their heart are going to be adversely affected earlier. And so there are certainly many examples in the literature of people dying in an environment where multiple people are exposed, but one person dies at, and I've seen this, less than 20%, and the others die at varying levels above that. So it's not universal that everybody will require to get to 60, 70, 80%. That's a young, healthy individual. But people with predisposing conditions who are vulnerable will die at much lower levels.
So in terms of the literature, are you familiar generally with the literature on carbon monoxide poisoning?
Yes.
Specifically, are you familiar with the paper by DeMaio and Dana on carbon monoxide poisoning in open spaces?
Yes, that is a paper that came out in the late 80s, I believe.
And is this here as a part of your PowerPoint, that article, or the title of that article?
This is the title sheet or title portion of that particular paper that was published by the two doctors. Yes,
And that was in the late 80s, you said?
correct.
Are you familiar with CDC warnings on carbon monoxide in open spaces?
Yes.
Can you describe what this slide represents?
So this is the outdoor air recommendations. So we're not talking about indoor air, outdoor air
No, never.
recommendations by the
Not
EPA.
not once ever. No.
And recommending that
would go to
individuals
jail
are
for
not
that.
exposed to
We were
more
not
than
allowed
9
to do
parts
that,
per
no.
million for 8 hours. Anything above an 8-hour exposure puts you at risk of absorbing carbon monoxide, which can put you at risk of at least symptoms, if not more. And when you go up to 35 parts per million, so not much of an increase, that exposure limit drops to 1 hour.
So in terms of the CDC versus the EPA, what does the CDC say?
Well, they both saying, just be careful of carbon monoxide, regardless of your environment.
Are you familiar with the Consumer Product Safety Commission scale? Excuse me, the Consumer Product Safety Commission.
Yes.
Is that the information that you obtained for this case?
So this is the top of the page
Okay.
that they refer to, and
Yeah,
if you go
they're
to
still
the
on
next
this guy.
slide, it actually says what it says on the page. And basically they're saying that most people will not experience any symptoms from a prolonged exposure to carbon monoxide between 1 and 70 parts per million. But some heart patients may experience an increase in chest pain. In other words, become symptomatic in that range. As CO levels increase and remain above 70 parts per million, symptoms become more noticeable and include headache, fatigue, and nausea. And once you get above 150 to 200 parts per million, people become disoriented, unconscious, and death are possible. So the higher the level, the more rapid and the more serious the potential consequences of exposure.
Yeah, the
to a
prosecution
source of
proved that it was on the
carbon
neck
monoxide.
90%
Are
of the
you
time.
also
It wasn't on
familiar
the neck
with
the
the
whole
World
time.
Health Organization standards?
Yes.
Is that the next slide?
So this is just, again, the header from their document. The relevant information is on the next slide. And they go a little further than the EPA, giving us more data. And what they do is they've got the same 9 parts per million for 8 hours. Their recommendation
Whoa,
is
gotta
not
check
more
that
than
one out.
26 parts per million for 8 hours, not the 35 that the CDC, the EPA has. At 52 parts per million, the risk of exposure issues occurs in 30 minutes at 52 parts per million, which is in that 1 to 70 range that the EPA said is okay. And then at 87 parts per million, 15 minutes is all it takes to start getting yourself into having absorbed a decent amount of carbon monoxide.
Now, you're not a mechanic, correct?
No.
All right. But are you aware of some just sort of general standards in terms of the emission of carbon monoxide by vehicles?
Yeah,
Yes,
they're just saying
it's
that there's
part of
other causes of death. It's
the
not
general
Chauvin.
knowledge
That's
of
what they're
forensic
doing here.
pathologists have as to the
Not
different
Chauvin.
types of sources of carbon
CO
monoxide.
And
carbon
would that
monoxide.
include the California Air Resources Board?
Yes, this is one of the most strict automobile emission regulations.
And what does the regulations stand for?
So in California, and it's been adopted in about 14, 15 states around the country. So California has been copied by various other states. Some states have not copied it. I could not find any reference to Minnesota being a CARB state.
Okay.
So, but adopting the California stringent regulations, a vehicle may emit up to 1,200 parts per million of carbon monoxide from its exhaust.
And going back to the prior slide, where would that fall within the World Health Organization? World Health Organization guidelines?
Well, they go up to 87. We're talking 1,200. So we're talking in excess of 10 times. 12,
Now-
13 times.
Now, again, you're not suggesting to the jury that Mr. Floyd died of carbon monoxide.
Not exclusively, no.
How would you be able to determine the role that carbon monoxide played in a particular death?
Typically, and the easiest way for a medical examiner to do that is to have the
Yeah,
blood
essentially.
tested by a laboratory.
The more causes
for
of death,
what we call carboxyhemoglobin
we don't know what's going on, right?
saturation. And it will come back from the
and this is essentially
laboratory
what
giving
this
us
is. Throw
a
everything out
percentage
there, and
saturation.
we don't know what it was, right? But
To
it
your
wasn't
knowledge,
Chauvin.
was Mr. Floyd's blood tested for carbon
They don't
monoxide?
know. So how could you know?
find a
They don't
reference
know.
to it, no.
Now, the previous articles that we kind of looked at, the DeMaio, I think you said, from the late 80s, are there more recent studies on the effect of carbon
I don't know.
monoxide exposure
Good question.
in open spaces?
Yes.
Is that this? Oops.
Mm, yeah.
No. May have gotten mixed in here.
I don't think I put this into the PowerPoint,
Oh, okay.
Mr. Nelson.
Uh-oh.
All right.
Yes, there's a recent study or case report that came out of Poland, where a taxi driver committed suicide by taking his vehicle, parking it in an open space, taking one of the mats out of the vehicle, putting it behind the vehicle, and then lay down on the mat and inhaled the exhaust. And he ended up with a very high level of carbon monoxide. It was in the 80s. Certainly sufficient to be an exclusive cause of death in that particular case. The interesting thing about that particular study was it provided no new information as carbon dioxide is dangerous. Carbon dioxide comes out of exhausts, and you can do this because it replicated what DeMaio and Dana had done 20, 30 years before. But what was done in that particular case was that the authorities tested the amount of carbon monoxide coming out of the exhaust. So they did a recreation, reenactment, and took carbon monoxide sensors and put them at approximately the place where the man's nose and mouth were, and then monitored the carbon monoxide coming out of this vehicle. So the principle that you can test a vehicle and make a determination exactly how dangerous it is was properly tested in that particular case. And they found that when the breeze was blowing or the wind was blowing at or about this man's face, and he was about a foot away, to give you a reference, when the wind was blowing, the amount of carbon monoxide picked up by the sensor was 200 parts per million. And when the wind dropped, it went up to 790 parts per million, which is, again, almost 10 times the World Health Organization's recommendation. So in the area close to an exhaust, you're going to have a much higher level of carbon monoxide than you would if you're 3-4 feet away.
Okay. Now, to your knowledge, were similar experiments done in this case, or recreations?
I did not see any information that indicated that a similar recreation or was done in this particular case. No.
In terms of modern vehicles, they have catalytic converters, correct?
Absolutely.
And what does a catalytic converter do relevant to carbon monoxide?
It reduces it dramatically. So in the era before catalytic converters, the amount of carbon monoxide coming out of a typical car exhaust would exceed 30,000 parts per million and could be as high as 70,000 parts per million. So the catalytic converter and the modern emissions controls that you see on, at least in the California requirements, which are, again, the most strict, have reduced it by about 30 times to somewhere close to 1,000 to 1,200.
Now, in terms of...
But what about Minnesota? We're in Minnesota. So why are we talking about
can you
California?
describe for the
emission
jury
standards?
what a pulse oximeter is?
Yes, a pulse oximeter is a device that you put on the finger. It's a little clamp that you put on the finger, and it reads two things: your pulse rate and the oxygen saturation in your blood. So it counts the pulses and it reads how much oxygen.
Yeah, I'm trying to figure out where they're going.
in
He
your
did
blood
have
by looking at the
89%
color of
CO2.
your fingernail.
So
How
I don't know how he's getting
how does
this
carbon monoxide
carbon monoxide.
come into play in terms of pulse
It
oximeter?
just doesn't make sense.
So the important thing is it appears to be oxygen. It changes the blood to a color which the pulse oximeter thinks is oxygen. So if you take somebody who has 50% saturation with carbon monoxide, it will still read that the person is 95%.
I think they're just letting him burn
oxygen.
himself, because
It
if
doesn't
he
tell
goes
you that
through all
there's
this
50%.
stuff
So
out of scope, you kill it on cross.
if
Cross
a
examination is where you
pulse oximeter was
kill
put
that.
on Mr. Floyd's
You let him talk
finger in the
about stuff he
vehicle
doesn't
and
know.
again in
Because
the
on cross, you
hospital,
kill him. That's
the
what I
pulse
would do.
oximeter does not give us any information allowing us to say he was or was not under the influence of some degree of carbon monoxide intoxication.
How long does carbon monoxide typically stay in the bloodstream?
So it stays in the bloodstream. If you want to treat a person and put them on 100% oxygen, the half-life is about an hour and a half to 2 hours. If you're exposed to ambient air, it takes much longer to get rid of the carbon monoxide.
And so, I mean, essentially removing that carbon monoxide from the bloodstream is a reversible process.
It's not an irreversible bond, it is reversible. So yes, it will at some point slowly dissociate and be blown off. We do generate a small degree of carbon monoxide as part of our normal metabolism. It's a very low, sub 1%, and it binds to the oxygen, to the hemoglobin, and eventually dissociates and is eliminated. So
All right, people. So YouTube has said that the stream which I was rebroadcasting from, which is a public stream, right? They're just really is copyright. So I just can't use the Fox stream. So I'm going to use another stream. And that's what just happened. So let me just get another stream up. Yeah, I know. So they told me to stop the stream, and I gotta do another stream, which again, this is a stream from of course a different stream would work. Actually, this is not copyrighted material. This is just BS, right? Because this is this all public information. It's just that, it is what it is. So I would definitely just even challenge that. But what I'll do is just go to another stream. It's fine. Let me go PBS. But PBS is so low with their thing. Let me just go. I'm just pulling up another stream, because you can't just you can't just sit there and say, let me share this. Let me share this public stream again from the court.
additional percentage of oxygen carrying capacity,
All right, here we go.
whether that be 5%, 10%, 15%, it takes away from the important factor of getting blood to his heart muscle. So this is just another
Yeah, we back.
potential insult.
YouTube said that I had to stop my stream because of
Now, ultimately,
the
officers were affected
this
by this.
court trial
No, they
was
were not.
They copyrighted
why
the
would
court
that-
trial,
why
which they
could that be?
cannot do.
Well,
This
they're
they
another
can't
2 to 3
copyright
feet
the court
away.
trial.
And potentially,
that's
hopefully,
ridiculous.
they're much younger and hopefully don't have heart disease. So with every foot or more away the amount of carbon monoxide in that particular bubble is going to decrease.
Now, so we've discussed the heart, we've discussed carbon monoxide. Did you eliminate certain causes of death as well?
Yes,
Specifically referring to asphyxia.
correct.
How would you describe the investigation of
Yeah.
custodial
YouTube
deaths
just
compared
is
to
block. I don't know what
other
YouTube is doing.
types of-
They said this is copyrighted material. It's not copyrighted.
Very
material.
long,
What are you talking about?
very complex.
This is a
and
public trial. This
something
is
that
coming
needs
from the
to be
court.
done
So
very, very
it is what it
carefully.
is.
Are there many variables to consider?
Absolutely, there are huge number of variables, as we obviously can see in the case of Mr. Floyd as well.
Now, in terms of this article here in your PowerPoint presentation, what's the significance of this?
So this is an article that was put out, I think about 1992 by Dr. James Luke and Dr. Donald Ray. Dr. Donald Ray was one of the first pathologists to theorize that putting somebody in a face-down position was dangerous. And this was based on observations of cases where people were placed in a prone position and they died. And so his conclusion was that may well be a factor and needed to be considered. But what Dr. Ray also does say, and later on he recanted that to a large extent, but what he does say is that these are very difficult, complex cases. Don't rush to judgment. Make sure you've considered all of the potential issues that are at play in these particular cases. And they even talk about a crystal ball in this particular case, and the risk of underestimating the importance of common sense, and the fact that there are no easy answers in such deaths.
In your experiences as a forensic pathologist, have you had the opportunity to perform a death investigation and autopsies of in-custody deaths?
Yes.
So in this particular case, we've heard a lot about hypoxia. Which organ is more sensitive to hypoxia?
The brain is the most sensitive, or rapidly sensitive, to hypoxia.
In your review of the materials, did you have an opportunity to review some testimony of Dr. Baker in prior proceedings?
Yes.
Dr. Baker, in his testimony, referenced some studies in terms of the effects of positional asphyxia. Are you familiar with those studies?
Yes.
Did you take those studies into consideration as far as your analysis of this case?
Yes, that is the current state of the science or the knowledge base with regard to this very difficult situation.
Yeah, they just pulled a
So
whole
let's
bunch of
talk just
strings.
simply
so.
about the prone position. Do people sometimes sleep in the prone position?
Yes, approximately 7% of the adult population sleep face down.
In terms of medical examinations, treatments, are people kept in the prone position?
In certain situations, people are examined in the prone position. There are therapeutic maneuvers where people are deliberately placed in the prone position. One of the best examples right now is COVID, where patients will be put in a prone position, which is face down, and it improves their ability for oxygen exchange, not decreases it. So, the prone position by itself does not have, or at least there is no evidence right now that is a significant issue.
In terms of this particular case, of course, the prone position is, not in a hospital setting, right? It's on a street, agreed?
Correct.
And I just generally speaking, if a person were to lay down on the street in the prone position with nothing on top of them, is that in and of itself?
Yeah, but you
inherently
can't
dangerous?
copyright
No,
public
scientific studies basically
public court proceeding. That it doesn't
have
work that way.
looked at the
They-
issue
If
of
they can
prone
copyright their
positions
lawyers talking
with
about it,
and
but there's a
without
public
weight,
stream of a public
and
case like
made
this
a
directly, and this is
determination
coming
that there
from the
really is no
court.
significant
You can't
effect
copyright
of
that. It's just it
individuals'
doesn't happen.
respiratory
So it's
function.
just YouTube. I think YouTube wants to
Those
funnel the content to
particular
certain
studies
certain people who
were
are
very
given
carefully
things, but
crafted.
I don't know. It's
Let me-
just it doesn't
Let me
make
just
sense. so.
interrupt you for a second, Doctor. Can you just, what's the kind of the leading study on weight applied to someone in the prone position?
I think there are several, but the one that I've recently read, well, not recently, but I know of, is the one by Dr. Mark Kroll and a couple of other co-authors.
And is that paper here?
Yes, I believe that is the one, yes.
Positional compression and restraint asphyxia, a brief review.
Yes.
Now, in terms of this study, can you just explain this study? Can you explain the setting of the study, etc.?
So this is a review paper where he refers to various papers, including his own work, where no evidence of any kind of compressional asphyxia was found in individuals who were in the so-called hog tie situation, which is prone with their hands handcuffed behind their backs, additional restraints applied around the ankles, and then the two tied together. That is the classical hog tie position. And then weights were applied to the individual up to 102 kilograms, which is 225 pounds, and found, again, no significant disturbance to their ability to exchange and breathe. And so the final conclusion was, and there are about 23 different studies out there that Dr. Baker referred to in his previous testimonies and that previous legal environment. And in this paper, Dr. Kroll says, positional asphyxia, as the term is used in court today, is an interesting hypothesis, unsupported by any experimental data.
So let me ask you, pursuant to the court's order, you were permitted to review the testimony or watch the testimony of other expert witnesses in this case, correct?
Yes.
And did you do so?
Some of them, not all of them.
Okay. Did you hear criticism of this Kroll paper?
Yes, I did.
And do you think that the study was flawed based on its methodology?
So the study was asking one specific question: is the prone position dangerous? When you craft a experimental process to look at a particular process, in this particular case was the prone, you want to eliminate all other variables. You want to eliminate fear. You want to eliminate exertion. You want to eliminate environmental conditions other than, and focus entirely on that one entity. So agree that